cell phone are turned off. There shall be no talking or closed session. Will you see it? Morning, Your Honor.
Thank you. Good morning. All right, if the attorneys would please place their appearance on the record.
Your Honor, Christina Stifler and Alan Mizrahi for the state.
Good morning, Your Honor.
Good morning.
Jose Baez, Patrick Caroli, Rosemary Peoples, and Armando Luis for Ms. Shanna Gardner.
All right, thank you. Good morning.
Good morning, Your Honor. Jesse Dreiser here on behalf of Mr. Fernandez, along with Shannon Day and James Hill.
Thank you. Good morning. All right. I am going to file the order related to I'm granting the defendant's motions for protective order. And I have exhibits that I'm going to attach to the order, but I'm going to direct the clerk to redact the contact information before posting and filing the order. Is that agreeable with all parties? The list that you gave me. So the list of attorneys' contact information that may be contained within the electronic evidence. Additionally, I didn't know if the lawyers wanted to redact certain portions of the evidence. It seems some of the email addresses appear to be that need to be redacted for public disclosure. However, I don't know if the lawyers have any issues with the actual evidence and how it's listed as being redacted. Do you know what I'm referring to?
No, I know the list, Your Honor, that I provided the court. Is that, it sounds like there's something else that you're referring to.
Yes, let me see the lawyers at sidebar. All right, so the lawyers are going to, Mr. Hathaway, they're going to stay, and by their agreement, certain portions that would be uploaded should be redacted, and they're going to remain and say which line numbers on the exhibits. Okay. All right. Is there anything that the lawyers would like to take up?
On behalf of Mr. Fernandez, Your Honor, we sent over a courtesy copy. Did you receive it for a motion to set depositions of minor witnesses?
No. When did you send it? Okay.
The motion appears as if, we're not communicating and having difficulty. It's not the case whatsoever. We have been trying to set, at the request of Mr. Fernandez's legal team, the depositions of the minor children of Jared Bridegan and co-defendant. there's no issue, no one has any objection to us setting the depositions. When we tried, and I expect, this could change, but I expect that we'll appear via Zoom, at least for Mr. Fernandez's legal team. The children are in Washington. When we initially had spoke about setting it, Mr. Mizrahi said that he would like to either have a guardian ad litem appointed or something to that effect. I said, okay, that's not my fight. That's really between the mother and the grandparents and the guardians and the children. Mr. Mizrahi reached out, and at any time, please jump in. The procedure, because it wasn't really my fight, reached out to a victim advocacy or a state attorney's office or someone to that effect in Washington, and they were going to have someone sit in. Somewhere along the way, that wasn't satisfactory to the guardians of the children or to my co-counsel. I'm not exactly sure. And then I think a guardian out there said that they didn't feel, that's already the children's guardian through the legal system didn't feel comfortable doing it, so they were going to ask the court to appoint someone. I don't know how long that will take. I don't even think they have court until mid-September. It's not even that I necessarily have a problem with that. I think the guardians do. I don't think they want more people in these children's lives than necessary, and I'll let them sort of speak to that. I don't really care who is there. I just know that if we don't set a date, you know, in the legal system, the wheels turn faster when there's a deadline. So I'm really just trying to get a date and some parameters put in place as to what is best for the children so that we can ask them about the same things that CPT asked them about. I mean, it's not going to be really, I don't think, any kind of a traumatic experience for them. But I think you should either hear from the state if I didn't say anything correctly, and certainly counsel, they have the most interest in protecting these children, and I understand that. We're not at odds with it. Anything you want to add?
Okay. Mr. Mizrahi?
That was generally correctly stated. From the state's perspective, victim advocate in place is, you know, the procedure and how we do things in the course of conduct that we conduct children's depositions here in Florida. So I took the liberty of reaching out to the local equivalent to child protection team in West Ridgeland, Washington, and Richland, Washington. And I talked to one of the supervisors there, and she said that they would assign, for lack of a better word, a Miss Juarez, Juarez, and she said she would be available when we schedule the depot to sit in with the children while the depots are being conducted. It was after that that Ms. Gardner's team indicated that someone was already appointed in the form of a guardian ad litem for I guess the dependency case, but then that lawyer said that he had a conflict and couldn't really do it. It doesn't matter, although I think the state's preference, let me specify, the state's preference is to have a trained victim advocate who deals with children on a daily basis in traumatic events to sit with them during deposition. And that is the state's perspective, as opposed to flying out our victim advocate from here all the way to Washington. It makes no sense, especially since our victim advocate hasn't met the children, to have a local person sit in with the depot and make sure the children feel comfortable. And I think we're all in agreement on that. But then, so.
Would anyone have an objection? And I understand it's not ideal, but if before the depot started, the victim advocate here, one of them, met the children, you know, via Zoom, talked to them, we create a breakout room that if any time, and then we just do it as we would normally do it, but electronically. I mean, I'm doing it via the internet, you'll be doing it via the internet. I'm not trained in that, but I don't know why that wouldn't work given.
I hate to do this on the record. No. I mean, I think the children cannot be, the children need to go, if these depositions are going to be conducted right, they can't be at home doing them. I think they need to go to a professional location to do these depositions so other people can see what's going on. You don't know what's going on in a Zoom room. And I'm not accusing anyone of anything, but then when you go through Zoom and you're doing a child's deposition, you don't know who else is in the room, and it's not the right.
Let me ask you, so as far as what you all have planned so far, Mr. Dreiser, you intend to appear virtually? Does the state?
Yes.
Okay. What about Ms. Gardner's team?
Your Honor, virtually, there are just a couple of things I want to perhaps clarify for you. First is, the children are in Washington State. The legal guardians are Mr. and Mrs. Gardner, the parents. Like Shanna Gardner, during the course of the investigation, who fully gave law enforcement access to the children, the Gardners themselves are not trying to frustrate this process. They're trying to facilitate it. They're willing to facilitate the appearance of the children via Zoom without any type of process, and schedule it at a time that's convenient to both the children and law enforcement. The issue here is that, as everyone can imagine, these children's lives have been turned upside down. We are trying to reduce the number of people who are involved in their lives, which is why the Gardner team reached out to the attorney who had been appointed by the court in Washington State in an ongoing guardianship case to see if that attorney would be willing to sit in during these depositions, because it is the state that is insisting that the children and the Gardner family cannot be trusted.
Objection. You know,
Oh, let him finish.
I'm not going to let him, okay.
Your Honor. And so, that attorney unfortunately said that she does not feel comfortable doing it. However, based on the status of that case, she is going to, there is a court hearing, I believe, today, during which she was going to ask the court to appoint individual attorneys for both children, and that she would bring my request to the court's attention. We do not know what that family law judge in Washington State is going to say about that request, because that judge has not addressed it. But our position on behalf of Ms. Gardner and the Gardner family with this court is that, one, they want to facilitate and they want to assist in completing these depositions with the least intrusion into the children's lives, and the idea of inserting one more person into their lives without exhausting all other options of who can sit in and be this third-party observer. Either they're not going to agree to that at this time. So we are trying to facilitate it. We are hopeful that these new attorneys, who also have no relationship with the children yet because they haven't been appointed by the court, would be willing, with court permission in Washington State, to sit in on these depositions. But the state just said that their own victim advocate hasn't met these children either. And so why is that any different than bringing in new people into their lives in Washington State? What our position is that we would like to use people that are required in the guardianship case that have interactions and a relationship with these children. And again, this is all voluntary. There's been no service of process. We're trying to facilitate this in the best way we can in the best interest of the children.
Some of this seems a little, I think we need to be practical about it a little bit. So the state says that they want to have a third party. At some point in time, you would think that if they are called as witnesses, they would be brought to this jurisdiction to testify potentially. So what is the harm in having the victim advocate here sit in on the depositions?
There is no harm. I was coordinating just to have, I mean, whether it's the victim advocate here, when we fly out someone, a victim advocate here to fly out to Washington, I was setting it up in Washington. It doesn't matter to me who gets appointed.
I don't understand what the difference in this particular case would be. So, for example, that there is a criminal case going on. At the same time, concurrently, there is a dependency case going on. So in those proceedings, children would have guardian ad litems appointed. They generally speaking, at least in this jurisdiction, do not participate in criminal matters sitting in on depositions. A victim advocate isn't generally a lawyer, but trained for certain situations like what we're talking about. So in your argument, Mr. Crody, you are objecting to, or at least the family is objecting to one more person, but instead you're asking the court in Washington to appoint 2 new people.
We are not asking the court in
I
Washington.
thought you said it was being brought up by the lawyer.
The lawyer, there was a lawyer appointed by the court to do what is akin to a social investigation.
Right.
That investigation has been completed. The guardianship proceeding is ongoing. That lawyer, who's independent, is going to ask the court to appoint each child an independent attorney to represent the child's interests.
Because they believe it to be a conflict
I don't
in that
know why
proceeding?
that's their process, but I think that the lawyer that I spoke to is more akin of a lawyer to the court, and that not lawyers for the individual children, if that makes sense.
Yes.
So I believe that's what's going on. I also want to point out that, victim advocate services are not something that this court or anyone can force on a person.
True.
So, yeah, and if the idea is that we just need a third party to sit in the room and verify that no one is in that room holding up signs for the children and coaching the children, then that can probably be accomplished by someone else other than a victim advocate. The concern is obviously that these children, and I don't want to get into the services that they're receiving, but I can assure the court that they are receiving services. And so the idea that we need to put a victim advocate in there and force this relationship that no one believes is necessary, perhaps other than the state, we're simply not going to agree to that.
And typically, when I've done depositions in other locations, I think by rule and statute, I'm obligated to set the deposition within the jurisdiction that the people are in.
Yes.
And I generally do that at a court reporter's office in that jurisdiction or the courthouse. I've done both. So I was imagining it would be in one of those places. There would be
These are
bailiff.
children. So generally, it's in a less professional environment that's conducive for their comfort, like in a children's room or something like that.
And I guess if my point was, I would imagine whatever room that is, there'll be somebody in the room monitoring other than the family of the children. There'll be a bailiff. There'll be a person who runs that center. You know what I'm saying? I just don't see it being in their living room. I
agree with all this. This is why I wish we weren't discussing this in open court. We can probably solve all these issues. Everything I've heard is fine. If we do the deposition at the equivalent of the child protection team in Washington, I don't care who's in the room with the child, as long as we're the third place. I agree we should limit the number of people. I don't think it should be 15 lawyers in the room with the child. We all think that that's wrong. They don't have to have a relationship, but it's nice to have, there's someone there for the child in case the child has to go to the bathroom, in case the child gets upset. You'll have someone there that's taking care of the child, whoever that might be, that is there as a comfort to them. I mean, we're not developing relationships here. We're just making sure the kids are okay. And it shouldn't be this difficult.
I think that we can find a third party, whether it's a lawyer that's an officer of this court who flies out there and sits with the child and assures on the record that no one else is in the room.
I don't understand why y'all keep saying over and over that someone else is in the room. I don't understand that.
That's the state's concern, apparently, about the issue.
If I may, the child, if we're going to do this, someone's going to have to be in the room with the child, setting up the Zoom, making sure that everything's, and we're just going to leave a 11-year-old child in a room by themselves to give a criminal deposition, to have lawyers ask them questions for a long time. I mean, I think that someone should be in there, especially as Mr. Carodi has represented. These children are getting services and the like. I think someone should be there to make sure that they're okay. If the child starts crying, what do we do on Zoom? Go to a breakout room? There has to be somebody there in person that can help the child. And ideally, that's someone that's trained in dealing with children that have undergone traumatic incidents, as Mr. Carodi has indicated.
Have you researched locations that could accommodate this?
Yes, that we were going to do it at the center, at where the victim advocate's office is. They do it all the time. This is a child protection team. I think it's primarily sex crimes, but I'm sure they do physical abuse as well.
For depositions?
Yes.
Is that going to satisfy everyone?
Your Honor, my issue is that the term that the state is using is that they assign the victim advocate to the children.
I don't hear that, Mr. Crody. I think what Mr. Mizrahi is saying is not a deposition in the home. Is that what you're saying?
Yes, I don't think the deposition should be conducted in the home, but I think the deposition should be conducted with the least amount of trauma as possible to the child.
Your Honor, I would ask that I obviously can't answer.
Right, I'll let you all work this out. It sounds like it sounds to me that maybe there was a conversation that went sideways maybe about expectations, and to me, there's a practical solution to all of this. Either y'all can agree in a location, it's not someone that's gonna like really enter the children's lives just to facilitate a deposition. I don't see what the harm is in that, but if you do have an issue, bring it to my attention. And I also think a lot of whatever you're saying, a third person in the room, a lot of this could be solved by y'all buying a plane ticket and going out there.
Right, but that puts more people in the room with the child. But anyway, we're the parties are
I
going to
mean,
solve it.
I don't know what this third person in the room is, but, or other person in the room is all about. But, so I'm going to hold this motion.
Parties will solve it.
How about y'all get a date?
All I'm trying to do.
Let's get a date. Today. You want me to pass it temporarily?
I've provided my dates to Mr. Dreiser.
The minutia that you're going to have to hear. There's a 3-hour time zone difference. So the question is, after school is 8 p.m. for us, which is no problem. I work late all the time. Or doing it on a weekend. And I don't recall every email that was sent, but I know Ms. Stifler has a bunch of homicide trials, and they prefer not to do a weekend. I think the Gardners prefer to do a weekend because it will disrupt the children, and they won't be up late at night, during homework time and doing all that. So I think,
Y'all are going to get a date today.
okay. Yes, ma'am. Lastly, for Ms. Fernandez, I don't know what is all going on today, and I'm not sure if we intended on staying, if there was going to be a long hearing. I didn't know if you were going to give a past date or you went, and I'll accept whatever past date you give.
Okay.
Look it up.
All right. Let's focus on getting a date for the depositions. Okay. Mr. Crody, Mr. Bias?
Yes, Judge. In reference to the hearing, we have 3 witnesses. We'd like to call them first and then argue.
Okay. I'm going to take a brief recess then. You all talk amongst yourselves about this date. We'll put that on the record. I'll let Mr. Fernandez go. Okay? Court will be in recess.
When you do that,
All right, let's go back on the record. So, Mr. Dreiser, where did he go? Or Mr. Hill? Mr. Dreiser just said the depositions are set on September 20th, 2024. Is that correct?
That's correct, Your Honor.
State agrees.
Correct. I'm now in the process of sending an email to Washington to coordinate all that. I assume the deposition will last from 3:30 till 5. Can't imagine it going longer than that. But.
Sounds reasonable, Your Honor, but of course we'll defer to
Thank you.
co-defendants counsel as far as their time as well.
Mr. Crody, you agree?
Yes, Your Honor, and Gardner's willing to facilitate that, and we discussed the limitations on the role of the victim advocate.
Okay. All right. I can communicate the past date unless you all have some conflicts you want me to
Your Honor,
consider.
amongst the attorneys in our office, I'm sure one of us would be available for whichever day.
Okay, thank you.
We have Mr. Crody, Mr. Baez, send us an email or the court.
Sure. So if you all need to leave prior to the hearing, it's fine. I'll communicate the date.
Thank you, Your Honor.
All right, thank you. Mr. Fernandez can go back.
Yeah, make a call.
No, not yet. All right, and so I did review, I'm assuming the witnesses are related to the motion that was last filed. Is that correct, Mr. Crody? Yes, Your Honor. And I reviewed the state's response to that, requesting that the court summarily deny it. I still have the same view. I think that while not necessarily phrased that way, based on the law, I'm going to just do the inquiry. So if they want to present evidence, and I'll allow the state to respond in kind. So, Mr. Crody, you can go ahead.
Yes, Your Honor, we would call Susan Lee.
Susan Lee. Yes.
Good morning, Ms. Lee. I'm holding in front of me a two-page document that is 10 paragraphs by Susan Lee on 2020. And if you want to adopt that document as part of your sworn testimony. And Your Honor, I would like to admit defendant one into the record, copy of which has been provided to the city. It's a statement by Ms. Lee that she previously provided.
Any objection?
No, I'm sorry.
Okay. All right, that'll be defense one for the hearing.
Now, Ms. Lee, phone number 904-270 on June 23, is that correct? And on your smartphone, did that show up as a call from a particular agency or government agency?
I couldn't understand that. Did you say Minnesota? Okay, thank you.
Ms. Lee, when did you move to Minnesota? And prior to June of 2000. And as far as the date and time of that call, how are you the date and time of that call today in 2024? So it's on your cellular phone records. And if you go back and review those prior to signing that statement in May 2024. Now, there was did you answer that call at 2:52? Was there a second call number a minute later? Yes. Did you answer that call? And can you tell the board your own words about the exchange with the
I can't understand it.
Can you slow down, ma'am, a little bit? I know. Yes.
Can she try?
Judge, can we approach briefly?
Sure.
I think it's okay to be authorized.
Patrick, can you turn the volume down just like a tad? I don't know if it's the acoustics in here or what.
Now your headphones, so the acoustics are trouble. Can you try and speak for a second?
Miss Lee, can you just say test a few times? Maybe turn the volume back up. It's better without the headphone. Can you say it again? It's better. All right, I'm sorry. Do you need a read back?
No, I'm fine. All right. Ms. Lee, can you tell the board about the exchange you had, in your own words, the exchange you had with the person on the other end when you answered that?
Oh, she can't hear. Mr. Carody, before you sit down, the very first part of her answer, I could not understand. Yes, I got that her husband is African-American, something about the Mormon church, underworld. Like, shorter questions and answers, I think, would be helpful, because I can't understand it.
No objection, delete.
Ms. Lee, can you hear me? Yes. I believe your testimony, you were married to an African. And then sometime prior to July of 2016, there was also to you, that basically because to the Jacksonville underworld. And by underworld, he knew people that committed various crimes. And you shared that conversation with Kim Jensen and Kim Jensen's response was to agree with you that was ridiculous. To July of 2016. And then those text messages, what you would have told the detective, those, I think it's 8 text messages. Shanna, for knowing a magician. And knowing people. Your Honor, no further questions.
Okay, cross.
I don't have any questions, Your Honor.
All right. Do you want her excused?
Yes, Your Honor.
Okay, thank you. Mr. Bias?
Yes, Your Honor, the defense will call Kim Jensen.
Kim Jensen? She's not, no. Patrick's controlling it. Okay.
I think they were moved to a conference room.
Sure.
I'm sorry.
No problem. Mr. Hathaway, I'm going to give this back if you could give me a copy of it. Thank you.
you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Mr. Bias, why don't you
Sure.
use that podium?
There's a lever on the side from you, just a seat. The microphone. If you hear yourself over the speakers, everyone in the room can hear you, okay? All right? Address the mic.
Good morning, ma'am.
Good morning.
Has the witness been sworn? All right.
Yes.
Okay. Will you please introduce yourself to the court? State your name.
Kim Jensen,
Okay. And how old are you?
54,
And where do you currently reside?
Jacksonville, Florida.
Okay. And are you currently employed?
No,
Okay. So are you a homemaker?
yes.
All right. How do you know Shanna Gardner?
I met Shanna when she and Jared moved here from Connecticut, probably 10 years ago.
Can you speak up a little bit?
Sure. I met her at church when she and Jared moved to Florida from Connecticut close to 10 years ago, 9 years ago.
And did you know Jared Bridegan prior to knowing Shanna Gardner?
His family attended in our congregation, so I did know him.
Okay. And when you met Shanna Gardner, what kind of a relationship did you develop with Shanna Gardner?
Shanna and I became fast friends. She had been assigned to visit me each month in a program at the church where sisters would look out for a handful of sisters, and she had been assigned to me, and so we bonded over things like we both had a twin pregnancy, we both had a horrible pregnancy, and we just, she was actually in the youth program, and she was working with one of my daughters, and so she and I just became fast friends.
Okay. And are there other friends or a small group of friends that you have that you share in common with Shanna Gardner?
There are.
Okay. And are these other individuals from your church?
They are.
Okay. And is there a nickname that is given to you guys that you use for this group of friends?
The Lunch Bunch.
Okay. And who came up with that name?
It might have been me. I don't really,
Okay.
there was 8 of us, so I can't really, I really don't remember. We've been friends a long time.
Okay. And as part of, I'm assuming that as part of this bunch, you guys go to lunch. Is that
We
correct?
do lunch, brunch, breakfast,
Okay. And how would you describe the conversations that occur within this group of friends?
It was a safe place. We could talk about anything. We could be raw, we could be real, we could, not have to be politically correct. If anyone was struggling with, one thing or another, we could talk about it and, share ideas, thoughts, whatever. And it was just a safe place.
And when when a member of this group was going through marital issues, was that often shared within the group?
Oh, yeah.
Okay. And would off-color jokes or certain statements that you might not say in public, were they made in reference to another member of the Lunch Bunch's husbands? I'm trying to get to.
Oh, sure. There were more than one person that was going through a divorce at the time. Some of them were ugly, some of them were not so ugly, you know what I mean? But, we were just, we've got your back kind of a thing. We were very connected and very, I guess, just always looking for things we could do to help the other person, make things a little easier.
Who was the one person in this group that probably was a little looser with the tongue, for lack of a better phrase?
Probably me.
Okay. Now, tell us, well, let me actually get a little closer to where we're at. Did Shanna confide in you a lot of the issues she was having with her marriage with Jared?
Yes.
Okay. And did you guys give him a nickname?
Yes.
Okay. And what was that nickname?
Stupid.
Okay. And were you someone that Shanna would joke with when criticizing Jared?
Yes.
Okay. And were you also someone that she would confide in as to her feelings?
Yes.
Okay. And how would you handle that type of information? You know, what would you do as a friend when she's venting or speaking poorly about her husband?
So early on, before she was divorced
Right.
I mean, it really just depended on the day. Shanna would, you know, it would, back then, I mean, it was a long time ago. I mean, we would joke about things. We would joke about things that, you know, in any other setting wouldn't even matter. And, you know, we shared pretty much, you know, we shared a lot of things, like everything.
Okay. And what were things like for Shanna when the marriage ended?
When it ended and she was actually divorced.
Correct.
It was very difficult. Why was it very difficult? Well, prior to the divorce, their financial situation was an educational stipend that was given by their family. And Jared was in school. And when the marriage ended, that stipend ended.
When you say their family, whose family are you?
Shanna's family.
Okay.
Shanna's family provided a generous educational stipend that was utilized while he was in school. And when she got divorced, that ended. And at that time, Shanna had chosen to leave the church, and that caused a lot of hurt for her family. And so financially, she was kind of on her own, and she had 3 jobs, and, you know, this whole new transition with the children of, at that time, I think it was like 2 days, 3 days, 2 days. It was just, it was, the math was worked out to where every other weekend, one or the other parent had them for the full weekend. So one day you might have them, you know, whatever, however it worked out.
And then subsequent to that, did things change when she met? Well, take us through a little bit further in time. When did she actually meet Mario Fernandez?
I don't
Be
know,
approximate, it doesn't have
a
to.
couple of years after she was divorced.
Okay. And then how did the situation change with Jared and the communication with the kids and things like that?
I'm not sure I
Sure.
understood.
Can you give us a general description of how things progressed from that point on?
From the time she married Mario?
Yes. The relationship with Jared.
The relationship with Jared really never changed. It was always bad. Communication was bad because there was never verbal communication. It was all electronic. It was either text or email. So things were often misunderstood, and I mean, they were not good at co-parenting.
Okay. And did Shanna have issues with talking to Jared?
She would have preferred to pick up the phone and, you know, but it was him. He was adamant that there would be no verbal contact.
Okay. Now, I want to take you to 2022. You were, I guess, were you close to Shanna when Jared was killed?
Our friendship?
Yes.
Yes.
Okay. And during this time, what was life, shortly after he was killed, what was life like for Shanna during that whole time?
Everything was focused on the kids, their well-being, their mental health, increasing therapy appointments, giving them, space to grieve, and, just making sure she spent a lot of time in talking with the guidance counselor at school. Everything was just focused on the children.
Okay. Prior to Jared passing away, was it already established that Mario Fernandez and Shanna Gardner were going to get a divorce?
Yes.
Okay. And what types of things were being planned out for that?
They had made a plan that I don't remember what month they actually told the kids they were getting divorced, but they had made a plan that they would let them know what was happening, but that they would continue living in the home together until school was out, so that it wouldn't disrupt.
Okay. Now, did you cooperate with the investigation in this case?
Yes,
Okay. So when the police asked you to come to the police department and make a statement, did you do that?
I did.
And they sat you in a room and you had conversations with the detectives in this case?
Yes.
Okay. And subsequent to that, what type of contact did you have? Well, let me ask you this. How many times did they ask you to come in and talk to you?
The first time was, 3 or 4 months after the murder, and then again the following year in January, I think.
Okay. And then did there come a time where you were asked to testify before the grand jury?
Yes.
Okay. When was that?
February.
February.
Last year, 23.
Okay. And did you comply with the subpoena and go and testify?
I did.
Okay. And prior to going in to testify, did you have any contact with any of the prosecutors in this matter?
I did.
Okay. And who did you communicate with?
When I got there, I believe Ms. Stifler was the one that greeted me, and then they put me in a room and told me that I would be there until I was asked to come in. Mr. Mizrahi came in and spoke with me.
Okay. Before we get to that conversation, I want to ask you about this. What was your relationship like prior to the grand jury with law enforcement?
I didn't really have a relationship with them. I'd talked to them twice. They said it was victimology. Used to say things like, you have the unique position of knowing Jared and Shanna and Mario. You know what I mean? Just, I didn't really think anything of it. I just...
Was it ever contentious prior to the grand jury?
No.
Okay. What about your relationship with Ms. Stifler and Mr. Mizrahi? Was that ever contentious prior to the grand jury?
No. I didn't have a relationship with them prior to the grand jury.
Okay, so was that the first time you met them?
Yes.
Okay. And then what occurred when, after you met Ms. Stifler and then you met Mr. Mizrahi?
Mr. Mizrahi, I was in the room alone. I was quite nervous. I didn't know what to expect. I'd never done anything like that. He came in the room, told me how important this was, that that they knew things that I didn't know they knew. that I was in a lot of trouble, that I had to tell the truth.
Let me stop you there. You said that you were in, did you say he said you were in a lot of trouble?
Yes, that I could be in a lot of trouble from this, gave me some statute about if you lie to a grand jury, you could go to jail for 30 years. It was very, I didn't go in feeling comfortable. How about that?
Say that again. I'm
I
sorry.
didn't go in feeling comfortable. My nerves were like you know what I mean? I was very nervous. I didn't know what they were going to ask me. I didn't know why I was there specifically in relation to the murder because I didn't have anything to do with anything.
Okay, so why did you not go in there feeling comfortable?
Well, like I said, it was an uncomfortable situation, and I was made to feel more uncomfortable with, Mr. Mizrahi made me feel more uncomfortable.
Okay.
It was the tone, it was the, you know what I mean? And I was scared. I'll be honest, I was scared going into this because I didn't know what was happening exactly.
Was his conversation with you one that he was just being informative, or was it more than that, or different? Describe to us. I don't want to put words in your mouth. Tell us how you would describe his interaction with you.
Well, I mean, that was the basic interaction prior to going into the grand jury. Post, I went into a room yet again, and he told me that he knew it was uncomfortable. He thanked me for coming. He knew it was an uncomfortable situation, and that it was very intimidating, but that was his job because when you're uncomfortable, you say things that you wouldn't normally say, I think is how he put it.
Okay. Did he give himself a name?
No.
To
No, not-
describe the situation of being uncomfortable? Or,
He said that he used words like intimidation and, those are and when you are intimidated and you're uncomfortable, you say things that you wouldn't normally say, and that's why it had to be that way.
okay. So, did you find it intimidating while he was questioning you before the grand jury?
I did. It was very frustrating.
Okay. Were you ever accused of lying? Or not being straightforward?
Yes.
Okay. How many times?
Maybe once or twice. I can't really remember.
Okay. And did you ever feel confused at any point in time?
Yes, because there was a constant hammering of they wanted to know exactly, when did this happen? When was this said? And I couldn't, I was nervous. You know what I mean? My watch is going off for my heart rate. It was an uncomfortable day, and it was a long day.
Okay. So now let's fast forward a little bit to the next time you had contact with law enforcement and the prosecutors. When was that approximately?
Together or law enforcement, just by themselves?
Either one.
So the grand jury was in February, and in April, they had a search warrant for my phone. They
Okay.
took my phone and my watch in April.
And you gave those to them?
I did.
Okay. And then subsequent to that, when's the next contact you had with any one of them?
Next time was in July of last year.
Okay. And tell Judge Kite what happened in July of last year.
I was leaving my neighborhood, and the officers were pulling in. I recognized the Explorer, and I kind of saw him, and I thought that it was Detective Johns. And so I pulled out of the neighborhood, and they flipped around and followed me to the red light. And once I proceeded through the red light, they flipped their lights on. I pulled into the Publix parking lot, and they told me that I needed to come with them to speak with the state attorney's office.
And were you free at the moment and fine and ready to go, or?
I was not. I told him I wasn't actually dressed appropriately. I was actually headed to the gym. They told me it didn't matter. They needed to speak with me now, and that they were going to drive me there and bring me back to my car as soon as I was done. And I said, that I wasn't comfortable with that. I asked to call my husband. I did. He's like, why would you ride with them? He's like, are you under arrest for something? And I asked him, and he said, oh, no. We're going to leave your car here. You're going to come with us. I'll drive you there, drive you back. And I said, I'm going to drive my own car. And he gave me a whole big spiel about parking and how difficult it was, and that he had a subpoena that he didn't want to use, but that he would. It was an arsenal in his, or a tool in his arsenal, or something to that effect. And so I said, well, if that's what you have to do. And so he gave me the subpoena, and then he told me that it had to be, he was going to get in front of me, he was going to be the lead car, and, then the other car was, since I was sandwiched in, we're doing the O.J. Simpson thing, going down the freeway, and we end up here.
Okay. And what occurred when you got to the state attorney's office? Where did you go?
I was in a conference room, or I was put in a conference room. There were blown up text messages.
Let me stop you there. Okay. You're put into a conference room,
Yes.
correct?
Yes.
And who was in the conference room with you when they brought you up to the conference room?
Nobody. I was put in the conference room alone.
But what did you see while you were alone in the conference room?
So it was a long table. I was sitting at it, and there was several blown up text messages between me and probably, I want to say 3, 4, I don't know, between me and the girls.
When you say blown up, how big?
I don't know. Like half a poster? I don't know, maybe.
Half a poster size? Okay.
Maybe. I mean, big enough that you could see it without, squinting. And then there was another board there was like a board on the side that had a picture of Shanna and Mario and Henry Tenen and me on there.
And what did it say?
I think it said something like conspirators or conspiracy to murder, or co-conspirators, maybe it said. It was like it was done in a circle, like.
What was your reaction to seeing a poster at the state attorney's office with your photo alongside Henry Tenen, Shanna Gardner, and Mario Fernandez?
I was very taken back because I was very taken back. I couldn't imagine where they were going with this because, I was just Shanna's friend.
Okay. Tell Judge Kite what happened next.
Mr. Mizrahi came in, told me to take in the room, and they would be there shortly. I don't know, I was in there by myself 15 or 20 minutes, and I was just reviewing everything, and then the prosecutors came in and they said they were sit down, we were going to talk questions, and Mr. Mizrahi asked me if I knew why I was there, and I said, detective said you had some questions, and he said that the police wanted to arrest me and take me to jail.
And were the police there right in that room? Who was in the room alone?
Not at that time. I was just in there with Mr. Mizrahi, Ms. Stifler, and I think there was someone else.
Okay. Was that another member of the state's attorney's office? Do you know?
I guess. I don't know.
And after he told you that the police wanted to arrest you, how did you react? What did you say?
I said, for what?
Okay. And what happened after that?
It was another series of questions. They showed me that, the text messages were there, and, this is pretty damning. This doesn't look good.
Let me stop you there. So they began to question you about your text messages?
Yes.
Okay. And while you're giving answers to your responses to these text messages, did you ever see a recording device?
No.
Did you believe you were being recorded?
I mean, I really didn't think about that, to be honest. You know what I mean? Like, I knew that when I spoke with the police that, you know what I mean, they would have a transcript or whatever. I mean, I really didn't know what their setup was. I guess it was possible, but I'm not sure that I really thought about that.
And did you write down your answers to the questions that they were asking you about your text messages?
No.
And if there's a dispute about what you said in response to the questions about the text messages, was there anyone else other than you and the 3 members of the state attorney's office? Is there anybody else there that would be able to verify that?
I mean, we were the only ones in the room, so no.
Okay. And then what happened next?
They asked me about the text messages, and, you know, and the text messages and then additional questions that they asked.
Okay. What happened after that? How long did that last, actually?
I don't know, I think I got in there around 8:30 or 9 o'clock, and I don't think I left till after 1,
Okay.
because I had an appointment at 12:30 that I missed. So I know it was after 1 or 1:30 before I left.
So what I mean is, how long were you alone in the room with the prosecutors?
Couple, 3 hours maybe.
Okay. And during that time, was it a friendly conversation? Was it contentious? Take us into that room if you can, and describe the conversations between you and the prosecutors.
At times, it had gotten very contentious. They got very frustrated with me. I'm trying to recall I can't remember the order, but, you know, there were questions about the text messages, and I would try to explain, you know, like, for example, the one was,
Well, we'll get into the specifics in a moment. I'm just trying to get a little bit more of the atmosphere.
right.
So at what point did the police come into the room?
Police didn't come in until probably maybe an hour before I was able to leave. It might have been a little longer than that, but they called it a roundup, that they wanted to go over everything and all the questions that they had asked me and have them be able to participate and hear what we had talked about, I guess.
Okay. Was it
A
word
summary.
for word or not?
No, it was like a summary.
Okay.
It was like a summary.
Got it. And was it as detailed as you had gone over with the prosecutors or not?
Some things were, I guess, maybe. Not everything. I mean, it was more of a summary. It wasn't, I mean, I was in there with them for over 3 hours, you know what I mean? And so, no, it wasn't as detailed.
Okay. Now, subsequent to that happening, did you have any other interactions with law enforcement? Subsequent to the July meeting at the prosecutor's office? When's the next time you saw someone from the prosecution team or law enforcement?
Well, today's the first time I'm seeing the prosecution team since the July meeting. And law enforcement, I only had one other encounter with them. They came to my home the week in May of this year, before the hearing that was in May.
So before the Arthur hearing,
Yes.
they came to your house.
Yes.
How many days before the Arthur hearing?
I don't know, I think they came on a Friday, and I'm not sure what day of the week that hearing was.
And did they tell you the purpose of their visit,
They did.
which was?
They told me that the state had sent them. They wanted me to know that my name was going to be mentioned in the hearing. And I said, why? Like, I was confused. It was a bond hearing. I didn't really understand the purpose, you know what I mean? I knew what a bond hearing is, but I didn't really understand why I would be relevant to that. And they said that it was a mini trial, and so my name would be brought up, and they wanted me to know.
Did they try to educate you a little bit more about what was going to occur?
No, they said it was a mini trial, and I said, and you're telling me that the state sent you here as a courtesy to me? And they said, yes, that the state wanted to make sure that I was happy and healthy and safe. And I said, why wouldn't I be safe? And they said, well, we don't have any credible intel that you're not, but if you don't feel safe in any way, if anyone's following you, if someone vandalizes your home or your cars, we want you to call us. And even though we're not in your jurisdiction, we'll work with the people who are to make sure that you're safe. And it was the oddest.
Did that concern you, that the police were telling you you might not be safe?
Well, the whole conversation was odd, but that especially, like, it gave me pause. Like, what do you know? Like, what, you know what I mean? Why would I be unsafe? It didn't make any sense to me.
Did they insinuate or tell you that whose fault it would be that your name was being mentioned?
They did. I said, I asked them, you know, how involved is my name going to be in this? And they said that, that Shanna's attorneys had unsealed the grand jury, and that was, I mean, that was that was their doing, not the state's doing, and that, so testimony could be used from that, and that, that it basically, it was just a mini trial.
Did they make any negative statements about Shanna's defense?
Not just in general conversation. Detective Johns asked me if I had any questions at the end of this little conversation that we had, and I said I did. I said I wanted to know if they had any idea when this would actually end. When will there be a trial? And Detective Johns said that it had been their hope that there would be a plea deal, but because of Shanna's choice of attorney, that all these motions would be filed and this would be drug out, and they didn't see it going to trial before the end of 25 or the beginning of 26.
Was he referring to Mr. Cox or myself, Mr. Carodi? Oh.
He was referring to you. There was no Mr. Cox at that time. He said that you had the reputation of being a mudslinger, and that this would be everyone's fault except for Shanna's.
Okay. And subsequent to that, what happened next? Did you watch the Arthur hearing?
Oh, I did.
Okay. And did you see Detective Johns testify during that hearing?
I did.
And during that hearing, did you see the statements that were made in reference to you?
I did.
And how he characterized your statements?
I did.
Okay. I want to kind of go through some of those statements with you. Now, Detective Johns stated to you, well, okay, I'm sorry, strike that. When Detective Johns stated that well, first I wanted to talk about Susan Lee.
Okay.
Okay. I'm sorry. Before I get to the Arthur hearing, I wanted to ask you about the meeting with the prosecutors. When they confronted you with the text messages about Susan Lee, what did you tell them?
I told him it was a long-standing inside joke.
Okay. Explain that. Why is it a joke?
So the hitman joke was a joke between Susan and I years before I even knew Shanna. Susan used to, and I've known Shanna, I've known Susan for 25 years. So we've got a lot of history and a lot of inside jokes. But Susan worked for a member of the church who employed lots and lots of people, and she was his personal assistant, executive assistant, I don't know what her title was, but anyway, some years, probably 20 years ago, he asked her if her husband knew any hitmen, and she was taken back, and, when she got off work, the first thing she did was call me and say, "You won't believe what he asked me." And it became this, just anytime we heard the word, anytime, it could be watching a TV show, it could be in any context, it would elicit a phone call, a text, whatever, because we were laughing about it, that did he seriously think that her husband actually
But no, a hitman.
know a hitman, you know what I mean? Anyway, so it was that kind of a thing that just, so anytime we had the opportunity and heard about it.
Was Ms. Stifler present when you gave this explanation? Or did she walk out of the room at any point in time? She didn't, I'm just curious if she missed that explanation of the joke.
No, nobody walked out of the room.
Okay. And what was their response after you explained this joke?
I think Mr. Mizrahi said something like, "So you're telling me that the next time I see you, it's going to be with your attorney and you're going to explain to a jury that this is a joke," or something to the effect that it was ridiculous for me to say that these things were a joke when, in fact, it actually was, and the joke had nothing to do with Shanna, and it was years before I even met Shanna that, you know what I mean? I understand that the word sounds bad, but in the context that it was something that we had joked about for many years before I even knew Shanna.
Okay. So when you heard Detective Johns describing those text messages, did you hear him describe what your explanation to those texts were?
No.
Okay. Did you feel he gave an accurate description about those text messages as it related to Susan Lee finding a hitman for Shanna?
Absolutely not.
Okay. So would you characterize those statements as false or true?
I would characterize them as false in that the context was, the statements were there in print, but they were being inserted into a theory and not in the context that they actually occurred.
Okay. Now, is there anything else you could tell Judge Kite about those text messages or your explanation to the prosecutors and the police as to what they actually meant? Is there anything more light you can shed on that issue?
As far as the one between Susan and I?
Yeah.
I don't think so.
Let me ask you this question because I think it might come up. Did you have, after the Arthur hearing, did you have any contact with Susan Lee?
No, I have not spoken with Susan.
Okay, so the two of you never spoke and said, "Hey, wasn't that crazy?" or anything like that?
I've not spoken to Susan. I have intentionally distanced myself from anyone who might be on a text message that had anything to do with anything to try to keep the circle as small as possible instead of dragging more people into a mess.
And when you saw Detective Johns mischaracterizing what you said in those text messages, did that concern you? What was your reaction to that?
It was concerning because the way that he was portraying me, it was if I was involved in something that is completely untrue. I was not involved in any part of any of this. I was frustrated in that, I had tried to explain things and, clearly they weren't explained in a way that I felt like he was taking information from 2 years worth of whatever, interviews or whatever from multiple people, and I felt as though some of them weren't even my words, they were just kind of mushed into his testimony, like he was trying to go from memory on all of these things. Some things were inaccurate.
All right, we're going to go over those individually in a moment, but let me just ask you outright. Did you ever contact Susan Lee on behalf of Shanna Gardner to try and get her husband to find a hitman for Shanna Gardner?
I did not.
Okay. Was that even remotely your intent when you were texting her about her husband?
Absolutely not.
Okay. And was it just simply a joke?
It was simply a joke that had nothing to do with Shanna.
Okay. Then why did you, I'm just kind of curious, then why did you say Shanna needs a guy and then mentioned about a magician and all that?
Because Susan's role in our little friend group and in the church, Susan was in charge of the women's group. It was called the Relief Society. She had stewardship over all of the women in the church, and so she had an interest in Shanna. She was part of my group, my friend group, so she had intimate knowledge of Shanna and Jared and their marital issues and then the divorce, and she moved away at some point. I can't remember what year she moved, but she moved away, and she would often contact me and say, how's it going? And I was like, oh, things are going good this week, nothing really happened, or, oh, it's one of those weeks, she needs a guy. And I would say it in that way just so that she knew it was a bad week, and that's just how I spoke to her. That's
Okay.
just how I spoke to her.
Now, when Detective John stated that there were multiple conversations over a multi-year period about Mario killing or finding people to kill Jared, please explain to Judge Kite why that statement is false. Did you hear that statement? Actually, I should ask you first.
I heard the statement.
Okay. Was it true or false?
False.
Explain to Judge Kite why that statement was false.
Because I did not say that Mario was going to kill anyone. I was trying to explain, and I believe this all began in the grand jury. Am I allowed to say that? Am I allowed to say something that was said there?
If you can leave.
Your Honor, that's not correct. The state keeps saying this is unsealed. There's a very clear Florida statute on point that I believe the state even violated by showing the grand jury to Detective Johns. And your order only released it to the defense team, our lawyers and staff.
Hold on. Let me see y'all at sidebar, okay?
Okay, sorry. I know better.
We proceed.
Okay. Ms. Jensen, if we can avoid talking about what you actually said at the grand jury, let's try that, okay? If you feel you can avoid it with your answer, we'll take a break and figure that out, okay? So let me go back and ask you,
Well, do you understand what he's saying to you?
Not to repeat specific things that were discussed in the grand jury. There are several pieces of this that were discussed in multiple
Answer my
places.
question.
Yes?
Do you understand what he said to you? Yes or no?
Yes.
Okay, go ahead.
okay. So let's go back to the question or the issue at hand. Detective Johns testified that there were multiple conversations over a multi-year period about Mario killing people or finding people to kill Jared. Excuse me, about Mario killing Jared or finding people to kill Jared. Please explain to us why that statement is false. Why you did not tell them that.
The reason that it is false is because through interviews with both the prosecution and the police department, they asked me questions about Mario. I told them that Mario had a very large personality. He was famous for shock value statements, and that he had this one particular line that he would say repeatedly, which is, "Do you want me to take care of it?" Or, "Do you want me to take care of him? Do you want me to take care of it?" And that could be anything. It could be from a kid on the playground with one of the kids. It could be him overhearing a conversation between Shanna and I. He said it to me about my daughter was having an issue with somebody in college, and he said, "Do you want me to take care of it?" It was just, that was his phrase. And I believe it was Ms. Stifler who said, "You mean kill him?" But those were her words. Those were not my words. I never said kill him, ever.
When she said, "You mean kill him," what was your response to that question or that statement?
I don't remember what my response was, but probably no. I mean, that's what he said, take care of him. I don't know that there was a lot of,
And did you explain to the prosecutors and law enforcement that that was just a catchphrase of his and that essentially didn't mean anything to you?
right, it came, I mean, he was a big talker. He was full of it all the time, and I never believed anything he said, and it was never, I never felt that he ever said those words with the intent of harming anyone.
So if there are children playing in the playground, and you use that as an example, explain to us how he would say, "You want me to take care of it?" Tell me about how that catchphrase coordinates with something completely different than murdering someone.
So if the kids came home and said, you know, so-and-so on the playground was bothering me or picking on me or whatever, you know, his line would be, "You want me to take care of it?" And he was famous for, there was a group chat between both households with both sets of parents, and he always loved to be the first one to answer no matter what the context was, and, you know, and Shanna would always get upset with him and say, you know, don't, just don't. And it just, so as far as the playground goes, I mean, it's just, there was a kid bothering one of Shanna's kids, and, you know, we take care of it, and it was like, no, I got it, you know, we're good. So it was just, that was just an example of how it was used in all areas. That was just like his phrase.
You didn't understand it to mean he was going to go kill one of the kids, did you?
No.
Okay. Now, I want to move on to another statement by Detective Johns. Now, he testified that you made a statement about Mario having a motorcycle gang go and kill Jared, or, well, there's two parts to that question I want to ask you, but let's start with the motorcycle gang. Tell Judge Kite, was that an accurate statement? And if not, why is that false?
In one of the questions that I was asked about Mario, I had told them that he made shock value statements, And one of them, and they said, can you give us an example? And I said, well, I think one time he said that there was a motorcycle gang that met behind Jared and Kirsten's home. And it just was, it just seemed ridiculous to me. It was a brand-new neighborhood.
Are you familiar with where Jared lives?
I know where they live.
And
or
based on the
neighborhood.
fact that you're familiar with that area, did you take the fact that, how was your reaction to him knowing a motorcycle gang?
It was something that he had said to Shanna, and I was just like, are you kidding me? He's so, you know what I mean? He's just, everything he says is so, it was just another ridiculous statement.
And did you express that to the prosecutors and law enforcement?
I did. I think I even discussed how it was a brand-new neighborhood, and I struggled to believe that a motorcycle gang was meeting there.
Now, again, did you believe that while you're answering these questions on a murder case with the prosecutors and the police, that you were being recorded, that hopefully your answers were being accurately taken down?
In hindsight, I guess it was an assumption, but I don't think I gave that much thought. I was just there, let me answer your questions and leave. Like, you know what I mean? I didn't give it a lot of thought.
Okay. Now, the next statement by Detective Johns was that Mario was so close to Jared that he could reach out and kill him or touch him or something along those lines. Do you recall that line of testimony?
I do recall the line of testimony.
Okay. Was that true or false?
That was another example of a shock value statement that he said. I don't think it was ever Mario. It was always, he has eyes everywhere kind of a thing. That, Shanna never needed to worry about the safety of the children when they weren't with them, that he had eyes everywhere. And he said, but it always toggled off of something that the children would have said first, and then maybe a statement was made, hours or days later from him. Maybe the kids said, oh, Dad went to a meeting, somewhere or something, and they would say, and then it was like, well, oh yeah, there was someone so close to him they could have touched him.
When he said he has eyes everywhere, was that in the context of he could keep Shanna safe from anyone, not necessarily Jared, or I'm a little confused on that.
He just led Shanna to believe that he had eyes everywhere. Like, you don't have to worry about anything. I've got eyes everywhere, kind of a thing. Like,
And
was the general feeling he wanted her to feel safe.
Is that what you meant when you responded to the prosecutors and Detective Johns, and not the fact that he was following him or was going to the point where he could kill him?
Yeah.
Okay. Now, I want to ask you about another line of questioning, or another line of his testimony. Did you hear the testimony about Detective Johns saying that you said Mario described these as missed opportunities, being, I guess, following him and them being missed opportunities? Did you hear him make those statements in the Arthur hearing?
I did. I heard the whole hearing, so I did hear the statements.
Okay. And did you ever say that to Detective Johns or to the prosecutors?
I don't recall the context of that statement. Like, I don't remember that particular statement as.
Did you ever make that statement? This is my question.
I don't recall that particular question of, when that statement, I was trying to think of where that one came from, and I don't remember.
Okay. Do you believe you even said or made that statement about missed opportunities? Does that sound like something you would say?
Depending on the question, I guess it's possible, but I don't think so, but I don't
Well,
remember.
Let me ask it a little more clear if I can. In the context of Mario having the ability to kill Jared and describing them as missed opportunities, did you ever describe anything remotely like that to the prosecutors?
I don't believe so, no.
Okay. And of course, no, I'll strike that. The next area that I want to cover with you is about this, about the testimony, Detective Johns testified about there being some delay of killing Jared because of COVID. Tell Judge Kite why that statement is false.
I never said anything about a delay in killing Jared because I never had any knowledge of Jared being killed or a plan to kill him. Again, the children had come home from a week at the other household and had told Shanna that Jared was working from home, that he got a different job and he was working from home. Not long after that, Mario had made a statement that he never goes anywhere. Well, neither did anyone else in COVID. Like, it just didn't seem like, you know what I mean? Like, it.
But was that statement in reference to going to try and kill him, or?
No,
that
it
statement
was just in general as the whole, I know where he is at all times kind of a thing. I know where everybody's, I've got eyes. Not necessarily mine, just eyes.
Okay. And I guess what I'm getting at, and I want to be clear because we don't know exactly what you said in that room. So I want to be clear about this question. Did any of that have anything to do with Mario having any animosity or intent to harm Jared in any way, shape, or form?
Mario didn't like Jared at all. Mario said oftentimes that,
But I want you to answer my question if you can. The statements surrounding the fact that he didn't go anywhere.
Right.
Was that in reference to him attempting to go kill him or anything like that, or cause him harm in any way, shape, or form? Or was that just Mario talking about Jared in a general way?
I would say it was just Mario speak, his grandiose shock value statements that he always says, depending on why he was making them. Was it a bad week on text? Was it it would just depend on the day.
All right. The next question I want to ask you is in reference to the testimony that Detective John said, you said during this meeting that Shanna knew of Henry Tenen before he was arrested. Was that true?
Can you say the question again?
Yes. Detective Johns testified that there were conversations between you and Shanna about Henry Tenen before Henry Tenen was arrested. Was that a true statement?
The problem is, in retrospect.
And when I say arrested, I'm referring to being arrested for murder.
Right.
Prior to that.
Right. So this is where the disconnect is, and I think part of it might have been my fault with the prosecution. I never knew who Henry Tenen was by name or any, I didn't know who he was until that arrest. I had a conversation with Shanna in the fall after Jared had been killed. She was just telling me that Mario, it was a conversation about Mario, and she said that a guy that lived in the downtown house had been arrested. I never knew his name. I didn't put all the pieces together of who he was until after that was announced and the news started advertising that it was a tenant, which I think that his last name and tenant were maybe caused some muddied waters.
So you never knew who Henry Tennant was until it was announced he was being charged with the murder case?
Not at all.
Okay. So any statements by Detective Johns that those that you knew would be false?
They would be false because a lot of times I was answering questions after the fact. So at that point, I knew who he was, but prior to that, I did not. And I'm not sure that I ever made that as clear as I should have, because listening to some of the statements that Detective Johns made, it was obvious that he thought I knew who he was before I actually knew who he was.
Okay. Now I want to ask you about Detective Johns testifying about a week before the murder and this Hawaii trip. Are you familiar with that testimony?
Yes.
Okay. Now, was this another situation where, was this a statement of take care, was this a statement with Mario Fernandez making a claim that he would take care of that or something like that? His famous catchphrase, so to speak.
It was.
Okay. Describe for Judge Kite exactly what that was about, that conversation, what you told them.
Shanna had called me and told me that they had decided to get divorced. And Mario said, do you want me to take care of him? Or do you want me to take care of him? You know, I don't know him, I'm not really sure. And she said, Jared, and he said yes, and she said absolutely not. She said, I choose you. And that was the whole conversation.
Okay. When you say I choose you, was she referring that she was going to try and stay with Mario, or what? What does that mean?
No, because I'm not, and that was something that I tried to explain, was I'm not sure. They went to Hawaii at least once a year. Sometimes it was twice, but it was at least once, and typically it was an evaluation of, I mean, it was a trip, but they would always evaluate their marriage. They had different parenting styles. There was obviously, things were not perfect. And so they would evaluate whether or not they were going to stay married. And so I don't recall if it was that particular trip or the one, another one. I just know, I know that it happened. That conversation happened on a Hawaii trip, which one I wasn't sure.
Okay, and why aren't you sure?
Because Shanna and I talked a lot.
Okay. Now, then when you also, without getting into what you said before the grand jury, actually, I'll strike that. I don't want to complicate that issue. Did you hear Detective Johns make this testify about Susan Lee changing her phone number?
I did.
Was that statement true and correct?
No.
Tell us why that's false.
Susan's had the same phone number for as long as I've ever known her, which is 25 years.
Okay.
Even when she moved, she never changed it.
Now, did you ever explain the context of Mario's catchphrase with Detective Johns about take care of it?
Yes.
Okay. And how many times would you say you told him about that?
know. I mean, I feel like that kind of came up multiple times over the course of,
Now, we also saw numerous text messages going back as far as, I believe it's 2016, about a hitman. What did you tell them about those texts?
that it was an inside joke between Susan and I and didn't have anything to do with Shanna.
Even when Shanna would say, "I'm not joking"?
Yes.
Okay.
Well, that was 9 years ago, too. I mean,
I'm sorry?
so that was like 9 years ago.
Okay. What's the context? We saw text messages about funeral potatoes or casseroles. Can you tell us what was the purpose of that? What's the story behind that? Well, first, let me ask you this. Did you tell, when those text messages came up during the meeting with the prosecutors and the police, did you tell them what that was about?
Yes.
Okay. Tell us about that. What's the context of that? I don't understand that.
Well, the prosecutors were under the impression that that was a code word for planning a murder, which is patently false. Funeral potatoes is just like a little catchphrase in the church. It's like a staple food after a funeral. The people get served a meal, and typically it was that. At that time, back in 2015 or 16 or whenever it was, Susan was in charge of the women's group. I was part of the team that would help provide food for families who had lost loved ones. And I think I got asked to make funeral potatoes like 4 times in such a short amount of time. And so that kind of was like it was just a common thing at the time, because it was like, oh, more funeral potatoes, and, you know, so it was just, it's stupid, is what it was.
In reviewing those text messages, Shanna says some pretty ugly things about Jared.
Yes,
And fair to say you did too?
fair to say.
Why are you making these statements about Jared?
Because at that time, they were both single. During their marriage, Jared was very hands-off when it came to the twins. He didn't have a lot of interaction with them as far as taking care of their needs. And during the separation, prior to divorce, and then after the divorce, while he was just single, it was tossing the kids back and forth, 2 days, 3 days, whatever. Many times I would go with her to pick up the children. And the children would have gone to him on a Friday, and you're picking them up on Monday morning, and they were wearing the same clothes. They were 3. They'd had accidents. Their clothing had not been changed, even through the accidents. And
Let me stop you right there. I want to know really why you're sending these text messages that you would like to see him harmed too, or words to that effect.
because it was just more of a,
I'm objecting, this is well beyond the scope of the motion, we don't need to get into this. Her beliefs are irrelevant.
Well, it's reference to her statements. Her text messages were admitted where her statements are being made. I'm just trying to get her to clarify those statements that are within the text messages, or explain them.
The purpose of this hearing is not for a witness to sit there and badmouth our deceased ad nauseam.
And that's why I'm trying to bring it back as to why she,
Okay,
What's
to
the-
that extent, I'll sustain the objection if you'll just rephrase it and get it back to, I guess, the context and not her personal opinions.
give us the context of these text messages where both you and Shanna are talking badly about Jared.
it became obvious that the children their needs were not being met under his care.
Let me stop you there. would you, I'm going to try and lead, see if would you describe, is it fair to say that the two of you were just venting your frustrations with Jared Bridegan when you were sending these text messages back and forth?
Yes.
Okay. And were they ever serious in nature, or did you ever believe them to be true? Meaning, were they ever meant to harm Jared in any way? Were you serious about, I guess, poisoning him with lard and things like that? Were those statements and the negative back and forth between you and Shanna, were they ever did you ever take them to mean that you guys, or you, that there was any intent to harm Jared?
No.
Now, having said that, I want to ask you about another issue. Did Detective Johns ever confront you with issues that he had with the church?
He made it clear to me, and to even others who were interviewed, that he was not a fan of the church. He was not a fan. He didn't trust the church. He didn't trust the leadership, and questioned my. He had a whole series of questions about my feelings on when Shanna left the church and things like that.
When you say he was not a fan of the church, why do you think that?
What's the relevance of this?
Detective Johns testified significantly about the church and other witnesses related to the church. I think his position as it relates to that church bears some relevance as to his credibility or his potential bias as a witness.
So I mean, this has been months ago, but I recall, give me a moment.
I can withdraw the question. It's not.
Okay.
Well,
All I remember him saying is something that he had to do research about the church. I don't remember anything really beyond that.
Okay. If I can have just a moment, Judge.
Sure.
Ms. Jensen, the testimony you've given here today, have you given it to the best of your recollection?
Yes.
Okay. Now, have you had any medical issues that potentially could affect your memory or how you remember things, I guess?
I have.
Okay. What exactly occurred to you or what medical issue is there? Can you please tell Judge Kite?
A few years back, after a routine operation, I suffered a stroke and was in the hospital for several days, and it affected parts of my memory to where sometimes I jumble things, sometimes I have a harder time with timelines than anything, chronologically, remembering exactly, when something happened or didn't happen.
And have you discussed this issue with your medical providers?
Yes.
Okay. And is it your understanding that this is potentially because of the stroke?
It's absolutely because of the stroke.
Okay. did you at the time of the grand jury, and again, I don't want to get into your testimony, but at the time of the grand jury, did you advise the prosecutors about your stroke?
I did.
Okay. And the effects that it had on you?
I did.
Okay. And did that seem to sway them in any way, shape, or form in trying to get you to recall things?
Did it?
I guess, did that change them? What I'm trying to ask you is that, did they accept that as a response, or did you feel they accepted that as a answer as to why you couldn't recall things?
No.
Okay. Why do you think that? I'll withdraw the question.
Okay.
That last question, of course. I have no further questions.
You intend to cross?
I do, but it'll be brief.
Okay.
Good morning, Ms. Jensen.
Good morning.
Did anyone else in the lunch bunch, did any of those divorcees, were any of their husbands murdered?
Did they what?
Were any of the lunch bunch husbands that were getting divorced, were any of their husbands murdered?
No.
Okay. So this was a little bit unique. You would agree with that, right?
Sure.
Okay. I want to be clear, when Mr. Baez is going through all of the statements that I think you used, the catchphrases of Mario, those are coming from Ms. Gardner to you, correct?
Yes.
They're not coming from Mario to you, correct?
Some were.
Some were, but the ones about getting rid of Jared, the important ones, that's coming through Ms. Gardner, correct?
But again, you're putting words in my mouth. I never said getting rid of anyone.
Taking care of, the catchphrase.
Yeah, the catchphrase.
I'm just being clear because it's not at all clear in the record that, it sounds like from the record that you're hearing all of these things directly from Mario, when in fact you're hearing them from Ms. Gardner. Not that you've never heard Mario boast about something.
Right.
The particular statements that Mr. Baez was referring to in his direct examination, those came through Ms. Gardner to you.
Predominantly.
I asked her about multiple areas. Can he be more specific?
Which ones came from her and which ones didn't? If you want to go through each one of them. When he said he was going to take care of Jared, did you hear that from Mario's mouth, or did that come from Ms. Gardner?
From Shanna.
And did it come from Ms. Gardner when Mario told her about a biker gang that was hanging out behind the house?
Yeah, that was from Shanna.
Yeah, and did it come from Ms. Gardner when he was talking about Mr. Bridegan wasn't going anywhere because of COVID?
From Shanna.
And that he could reach out and touch him? That was through Shanna, correct?
Oh, that wasn't referring to him, but yes,
I
Shanna.
know, but you're getting it from Shanna.
Yeah, this whole thing is like a bad game. Detective John said that, Kim said that, Shanna said that, Mario said that it's like a bad game of telephone, like.
You're making my point for me. You don't know any idea what Mario is referring to other than what Shanna is telling you, correct?
Um,
Don't look over there.
no, I'm just looking in general.
Okay.
Sure. You know what I mean? I'm not going to argue the point.
Okay, so the answer is yes.
Yes.
And your medical condition has not improved in the last couple of years. You're still in the same condition you were when you were interviewed by the detectives and appeared before the grand jury and spoke to the prosecutors, correct?
Yeah, I mean, I'm stable.
Right, so it's not like a year ago you were in terrible shape and now you're magically better. You're basically the same person you were over the last several years.
Yes.
Thank you.
You just said Mr. Mizrahi was putting words, or they were his words, and one of the questions he asked you was taking care of Jared. the statement was, do you want me to take care of it? Not, do you want me to take care of Jared, correct?
Correct.
Okay, I wanted to clear that up. Now, when Shanna told you about the motorcycle gang, did you guys laugh about it?
Yes.
Okay. Were all of these statements that are described that we covered today, statements that the two of you were, for lack of a better phrase, ripping on Mario because he's saying all of these ridiculous things?
Yes.
And were you able to convey that to the prosecutors and to law enforcement?
I thought I did. I told them that most of the things that he said were just ridiculous, that I feel like I was very clear in saying that I didn't believe much of anything that Mario said.
And now following up on the cross-examination, when you describe them that these are conversations coming from Shanna, they're in effect, are they basically in effect the two of you laughing about things Mario said?
Yes.
No further questions.
May this witness be excused? Thank you, Ms. Jensen. Mr. Bias or Mr. Crody?
We have.
Yes, Your Honor, just one moment. Our defense would call Linda Lucetti.
I couldn't hear the name.
Sorry, Linda Lucetti.
Linda.
Morning, Your Honor. Thank you for having me in your courtroom today.
Good morning.
Yes.
Ms. People, why don't you stand at the podium over there so she can see you, okay? You may proceed.
It's volunteer work. It's our
Yes. Do you want-
Live privilege with court reporter.
Yes. Can I see that? There's a small microphone over there.
I'll bring you one.
Let's go.
Members of the media, while we're getting reset up, I just make sure, like, try not to zoom in where you're getting portions of the attorney's computers, because obviously they have materials on there that wouldn't necessarily be public disclosure, okay? All right, so just make sure, okay.
Your Honor, defense would move the sworn statement in as evidence at this time, as a defense exhibit.
What are we on, 2? All right, that'll be admitted as defense 2.
All right. And Linda, what was on that subpoena?
It was for 9 a.m. Oh, excuse me.
No, what was on the subpoena?
Okay. It was for 9 a.m. for me to meet with Detective Johns. It never said where.
And then what were your feelings when you received that subpoena?
I didn't know what that was about. I only knew that he was from County, Florida.
And then what happened the next morning? So then the next morning, at 9 o'clock by that subpoena, what happened? All right, now, at any time did you hide from Detective Johns? And were you willing to speak to Detective Johns? All right, and by partner, you're talking about your volunteer partner, Chris Thomas? Okay. Now, did you see the recording of the hearing before Judge Kite where Detective Johns testified last May?
Yes.
And how were you able to see that? And what were your thoughts on that hearing? All right. And how did he mischaracterize, now this is Detective Johns, your involvement? Right. At any time were you running, I believe the quote from Detective Johns was running frantically around the front of your house to hide. Is that accurate?
Oh, absolutely not. No, I have no reason to hide. He did not see that day. That was not home.
All right. And what were your feelings about his visit to your home that day?
I felt like it just wasn't comfortable. He was making
Now, after you viewed that testimony on the internet, what did you do?
I wanted to come across, but I didn't want it to come across. Refuse, or even assist with this check as needed. Made no, and protect. Also, to make an informed decision. Personally, I'm honest, I am not miscarriage.
Okay, no further questions, Your Honor.
Cross.
Good morning, Ms. Lucetti.
Good morning.
Can you hear me okay?
Can y'all use the microphone? It's very hard to hear when y'all are over there. Thank you.
Can you hear me okay?
Yes.
Ms. Lucetti, you said that your partner, Mr. Thomas with Intrepid, was willing to meet with Detective Johns and did in fact meet with Detective Johns, correct?
Yes, he met him in person on his front porch that morning, and my partner was home.
And are you aware that Mr. Thomas actually refused to grant an interview with Detective Johns or with the state attorney's office? But he did not grant him an interview that day, and he refused to speak about the subject matter with which Detective Johns wanted to talk to him about. After he retained a criminal defense attorney and required the state to serve his criminal defense attorney with subpoenas. Okay. And you said that you work with families in crisis on a pro bono basis. I have no further questions.
All right, may this witness be excused? Okay, thank you. Thank you.
Judge, all we have left is argument. I'd like to take a brief recess if we can set up PowerPoint.
Sure. All right, we'll be in recess for how long? 10 minutes? Let me see the lawyers on Moore.
Were you all able to?
I think we did. He wants me to remove something on, I will absolutely not. Do you mind if I just flip through to the next slide and not even address it?
I'm still going through it, Your Honor, but that's fine. We can begin.
Okay.
The call logs.
For the record, Your Honor, discussions to this day, we tendered Defense Exhibit 3. It is a transcript of Detective Johns' entire testimony. There'll be references to that by Mr. Vise during his argument, and at the state's request, they wanted that admitted.
Okay. All right, thank you.
And please, the court.
Yes, thank you.
There are several issues, so I'm going to try my best to do it chronologically for the court, and hopefully it would certainly sound a lot more fluid if I do it that way. But I'd like to take and direct the court's attention to how we got to the Arthur hearing to begin with. Obviously, we had the issue for the prior motion to recuse the state's attorney's office that preceded the Arthur hearing. We had filed our motion for bond, and I understand the court and the state preferred that the court dispose of the disqualification issue first before we ended up addressing the Arthur hearing. It was something we pushed because obviously Ms. Gardner's freedom is at stake, in addition to the fact that her main concern is she currently has a child with a terminal condition, and even to this day, every single day away from that child is absolute torture for Ms. Gardner. Having said that, we got to the Arthur hearing, and one of the first issues we had prior to it even commencing were these text messages of Susan Lee. So we were straight focused from the very beginning on Ms. Lee. The state argued that these messages were relevant because of Ms. Gardner's attempts to incite and induce others to kill Jared Bridegan. That was raised multiple times during their argument, but I think what's important is that we go through the timeline of the testimony and see how, in fact, that argument doesn't seem quite right. First off, Detective Johns testified about finding these text messages between Kim Jensen and Susan Lee. And upon finding these text messages, which, knowing the context, we all know the context of this case and how those messages would seem to be incredibly damning information because they are the only ones where there's an actual solicit to another individual to hopefully find a hitman. Upon finding these texts, we now know that Detective Johns reached out and called Ms. Lee on June 27th. Subsequent to that, we have the July meeting with Kim Jensen. So Ms. Lee testified that she had a conversation with Detective Johns, and it was brief, and she had agreed to have a Zoom call with them at a later date. We now know that that conversation or that Zoom call never occurred. In addition to that, that communication with this witness was never documented anywhere, and we only found out about all of this at the Arthur hearing. We now find out, in addition to that, that in July, when Kim Jensen went in, she explained the context of these text messages and the joke about Miss Lee's husband being African American and how it was something they teased her with, and it was an on-running joke. And as you heard Ms. Jensen today testify, that this is something that was a joke long before she even met Shanna. So that explains why the state, finding this incredible piece of evidence, never followed up and never had a Zoom call with Ms. Lee, because they absolutely knew that this that these text messages were made of a joke. And in addition to that, that also explains perhaps why they didn't file any police reports in reference to the contact. It also explains the fact as to why Miss Susan Lee was never placed on the witness list for the state of Florida. It's quite shocking when you look at the context of this case that those things would occur with such a big piece of evidence. But as the facts unfold and what was known to the state at the time, as early as July, was that these text messages were not going to be relevant to their case. But yet they came in here, they argued for him, and they argued specifically that this was an example of Miss Gardner attempting to solicit someone to kill her husband or her ex-husband. Then we get to Detective Johns' testimony. And if you could go to the next slide. I actually start with...
Mr. Bias, hold on just
Sure.
a minute.
And Judge, I'm not going to be reading or referencing the entire...
I can't see this on my screen for some reason. You want me to unplug it? All right, sorry about that.
Sure, no problem. I'd like to direct the court's attention to the last question on line 23, and for the record, it's page 41 of the bond hearing transcript, where the question is asked, and in your conversation with Ms. Jensen, she disclosed to you that she reached out to this person because of her conversations with Ms. Gardner. Answer, correct. Now, in the context of this would lead the court to believe that she had a conversation with Ms. Gardner about killing Jared Bridegan, and then she reached out to Susan Lee in an attempt to do so. But it completely omits the critical fact of what Ms. Jensen actually said these text messages signify. And to not advise the court of that is reckless. It's a clear attempt to mislead this court into thinking one incredibly damning fact that in fact is absolutely false and ended up being a joke, and albeit an inappropriate joke, but this case is riddled with that type of off-color humor. But the timeline of how all these things occurred, and the fact that they never placed her on as a witness and never advised us that she was a witness. Now, if we go through this discovery and we see these text messages, as a defense, we're going to be incredibly worried about the situation. And we would have, of course, the fact that they knew early on that these were a joke, we certainly would have liked to have had that information for the Arthur hearing so that we could have clarified for the court that this evidence isn't worth the paper it's written on. And to leave the court with that false impression that this was a legitimate solicitation for murder is befuddling, to say the least. So then we get to Detective Johns' actual testimony. When pressed on cross-examination, I asked him specifically, and if we go to the next slide. And this is, I would direct the court's attention to the paragraph on the right, the top question, where I asked Detective Johns, now you never spoke to Susan Lee, did you? And his answer is, I believe one of my colleagues did. That's a lie. We know that, obviously, from Susan Lee's testimony and how accurate she was in terms of being able to go back and look at her phone records. And subsequent to that, we also know that's a lie because after being pressed multiple times, if we could go to the next slide, where I come back to the issue and press, so you're the lead detective in this case, and you have text messages where they are allegedly looking for a hitman, and they call and they are texting someone. You got it right there in black and white, and you are texting a potential suitor for this hitman, and you never go and talk to the person who is the alleged person who they went to go looking for a hitman. His response now is, I believe at the time we were trying to locate her, her phone number had changed and we didn't have a good address for her, so we were not able to contact her at the time during the message. That doesn't make sense. But now, it wasn't one of his colleagues that spoke to her. She changed her number. And we also found that out to be false. So when you pull that all together of what Detective Johns did in his reckless disregard for the truth to try and convince this court that this was a legitimate search for an actual hitman, aside from the changing stories during cross-examination, he still stands with the benefit that neither the court or the defense know that Ms. Jensen had told them back in July of last year that this was in fact a joke. And they knew it was so much of a joke that they didn't even bother calling her or following up with her, but they still found it important enough to bring before the court as evidence to restrict this woman from her freedom and to keep her away from her children during pretrial detention. I don't think any lie would be acceptable for any witness before the court, but for a detective, the lead detective, to do that in this case, on this issue, which is such a serious matter, which I presume was an important issue for the court when conducting its evaluation. My cross-examination was only as successful because I didn't have this information to perhaps paint Detective Johns as either sloppy, negligent, or not fully prepared, because that's the best I could do with the information that I had. I pressed him, he changed his story, but at the end of the day, this is still a search for a hitman with Susan Lee's husband. It is not, I could not convince anyone otherwise because of the facts that these text messages look pretty damning. But yet, of course, as you know, both witnesses, both people who were actually behind the text messages were able to clear that matter up for the court and the defense at that point. But it wasn't until seeing this issue where Susan Lee is actually watching this and realizing what a gross miscarriage of justice that this was, that she literally went out and hired a defense attorney and then had that defense attorney reach out to the defense and clear up the matter for the court. We don't usually have that benefit. And this is textbook lying and hiding the ball by Detective Johns. And the fact that the prosecutors were present during these questions is another matter altogether. Now, then that takes us to Linda Lucetti. Well, if we can go up 2 slides, 3 to the actual transcripts, please. Ms. Stifler is questioning the witness at Mr. Detective Johns at this point and says, did you make attempts to speak with Christopher Thomas and Linda Lucetti and other members of the Intrepid Crisis Management firm? Answer, myself and one of my colleagues flew in an attempt to speak with them and they avoided us. That, as Ms. Lucetti testified to today, would cause serious doubt on that statement. Question, can you be more specific about your attempts to and their avoidance? Answer, well, Ms. Lucetti was running frantically around the front of her house as to hide from me, so I couldn't see, and she was in her house. Mr. Thomas was not in the office. I went to his residence, and he had his wife answer the door a couple of times to avoid speaking with me. While we don't have Mr. Thomas's testimony, we certainly have Ms. Lucetti's testimony that this description of events was absolutely false. And she felt it was important enough to bring forward and come forward and actually advise the court that this detective was again attempting to mislead the court. The fact of trying to avoid a witness is one thing, and then you have the fact that they actually they gave, the next slide, while in Utah, Detective Johns gives a Florida subpoena to a citizen in Utah, for which, as we know, this is not how it's done. And in addition to that, he has no authority to give a subpoena to a witness to appear in Utah. He has no such power. And then changes the date on it, as you can see, to a specific date and time for the next day, and then doesn't show. Never keeps his appointment with Ms. Lucetti. So Detective Johns' characterization of that part of the testimony is completely false, and there's a reason why. And it takes us back to the issue of the truck. Detective Johns' attempt to discredit Ms. Lucetti and her associate is kind of bootstrapping and covering up the main issue of what they attempted to do during the hearing, which was they specifically presented that on the night of Henry Tennant's arrest, that the next day there were a flurry of phone calls to this PR firm and to her attorneys. And as you know, and if we can go a couple of slides after the transcripts, here is the statement. And to be specific, and this is Ms. Stifler's question on line 13, and to be specific, Ms. Jensen told you she had conversations with Shanna Gardner about Henry Tennant, and those conversations before or after Henry Tennant was charged with the murder of Jared Bridegan. Answer, those were before. Question, so before Henry Tennant was publicly named as an individual involved in the murder of Jared Bridegan, Shanna Gardner and Kim Jensen had discussions about him. That's correct. And they had these discussions about owning the truck. That was one of the areas where they tried to mislead you into thinking that Shanna Gardner knows that Henry Tennant's truck was used in the murder before anybody else knows. So she must be the mastermind behind all of this, because she knows about Henry Tennant and his truck being used in the murder before the police ever make it public during their investigation. But this is not the only time they attempted to get that fact before the court. If we go to the next slide, as soon as, and this is an answer to a question, I apologize for not having the actual question, but it again states the issue about, no, I'm sorry, I'd actually direct the court to line 21. What did she say Ms. Gardner relayed to her? And this is to the PR firm, that their tenant had been arrested and that the tenant owned the truck that the police were looking for. Again, this is this fact, and it was brought up multiple times by Ms. Stifler to try and convince you that there's no way Shanna Gardner would have known or should have known that Henry Tennant's truck was used in the murder. But we know, but later on during cross-examination, I was able to clarify that. But again, here's another transcript on the next slide, please, where she basically states, and I'll start on line 14, can you describe for the court what your investigation uncovered as to Mr. Thomas's knowledge regarding the charges? And then answer, just that they weren't sure what the charges were, but it seemed unrelated to the truck or anything to do with Jared. Question, and again, I like the way she keeps using the word and again, and this is Ms. Stifler telling you again and again and again that at the time these messages are being sent, nobody other than the people who hired Henry Tennant would know of his existence as to a link to the murder of Jared Bridegan. Correct. Other than the Jacksonville police. Correct. I don't know how that's done. And it's multiple attempts to try and convince this court of a false fact. And normally I wouldn't say anything. I would put this one on Detective Johns. But this is a question, a leading question, that states all of these facts as if they're true, and they know them to be true. But in fact, they are false, and they know them to be false. The next issue, if we go to the next slide, this is one of their slides. And this is a slide that they use to convince the court that this is the timeline of events of the flurry of calls about Tennant's unrelated charges. Again, to try and show the court that she's scrambling because she knows, and she's not supposed to know, that Henry Tennant's truck was used in the murder and it's going to come back to her. And these times, I would submit to the court, are times that are taken from the timeline of this case and have been used, if we go to the next slide, in their probable cause affidavit in the support for application authorizing the interception of a recording device. Basically, one of their phone taps, they use this timeline specifically and these dates and times to lay out what occurred on that day. But as you can see, and what I brought out during cross-examination of Detective Johns, that Mr. Ordway, Henry Tennant's roommate, was told by the detectives specifically that Henry Tennant's truck was used in the murder. And I made a big deal out of it because, frankly, I think it's incredibly odd, and I have never seen in my career a detective giving sensitive information that hadn't been made public on a murder case to essentially a witness that could be, and by Detective John's own admission, could be involved himself. And he later, after not recalling, first he lied and said he didn't know anything about the conversation with Mr. Ordway, telling him he doesn't know what Mr. Ordway was told. And then upon being confronted, and I showed him the actual police report by his partner, Mr. Lamont, he then changed his story again, that he was told that in an attempt to get him to cooperate with them, to be a cooperator. And all the while, Your Honor, misleading you into the fact that there's no way Shanna Gardner or Mario Fernandez would have known that Henry Tennant's truck was used in the murder. It was a flat-out attempt, multiple times, as you can see through these transcripts, an attempt to mislead you, to take you down a path to think that this woman is absolutely guilty, with proof evident, presumption great, when they knew that fact to be false. There was a conversation, and clearly here, you see conversations between Mr. Ordway and Mario Fernandez, and then subsequent to that, those conversations, that's when these flurry of calls occur. Now, you take Ms. Jensen's testimony now, and you look at, and then we have the testimony of Detective Johns with this incredible meeting that occurred in July, where finally they had, and I don't know if the court understood this through the timeline of things, but she testified at the grand jury, but they didn't have her phone at the time. So after the grand jury, they then had her phone, and they extracted her text messages, and that's why they called her in July and had this meeting, and they put her in this room, I guess this intimidation room, for lack of a better phrase, to sit there and sweat it out. And then we have two very experienced prosecutors, making themselves witnesses in this case because they chose not to record it. They chose not to write a report about it. Well, they can't write reports, but they chose not to have a police officer present. 3 members of the state attorney's office alone, for, as you heard Ms. Jensen describe, confronting her with text messages, asking her statements about critical facts in this case, and she is giving them information that a lot of these things were jokes, that's the way we talk, that's a catchphrase, giving all of this exculpatory information that could help Ms. Gardner's cause to get a bond at this Arthur hearing, that could help me cross-examine this witness a lot more, and we were denied that as well at that very critical stage of these proceedings. You have one situation, okay, and we dealt with that situation where I think when we had the disqualification issue of the state's attorney's office, albeit a completely different matter. And then we have Detective Johns, not just lying once, but time and time again on major critical facts and withholding information, misleading information, and flat out false information. This has no place in a court of law. This detective knows better, and these questions are completely inappropriate. And it was riddled throughout the entire Arthur hearing. One misleading fact after another, after another, after another. And as you heard Ms. Jensen describe, all of these explanations occurred without anyone documenting anything now. Now, I am stuck with a situation where do we now have to list Mr. Mizrahi and Ms. Stifler as witnesses? Because Ms. Jensen clearly has a different take of what she told them than they do. And perhaps the summary might be enough for us, perhaps not. But the fact of the matter remains is we've got a big, big problem here. If they intend on using these text messages, I want to know what this critical witness said specifically to law enforcement, but I have absolutely no way of doing that unless I call one of these prosecutors to the stand, for which we never want to do. Then comes, I would say I saved the biggest flat out lie for last. And I go back to the court's order where the court simply followed the money. It's where they started with their case, and they showed you slides. If we can bring up, the court may recall this $5,000 transaction on March 15th, from Shanna Gardner Irrevocable Trust. This incredibly damning piece of evidence was presented, highlighted here in a red box, and then the next slide, if we go to the next slide, we then show the transfer on April 26 from Shanna Gardner Irrevocable Trust. So you got one in March, one in April, and then they showed you other bank statements. If we can go to the actual Henry Tennant's standard checking statement. The court showed, the prosecutor showed the court checks here in March where Mr. Tennant made these deposits from, of course, Mr. Fernandez's account, which ultimately, as the court said, follow the money, and as the prosecutors told you to follow the money, Your Honor. And then we had the actual checks. These are, again, I'm using the state's PowerPoint slides to show you the actual transactions where they tied it all together nice and neat in a bow for you. If we can go to the next slide. And I'm showing these for just to, as demonstrative so that the court can recall this portion of the state's presentation. So we have all of these statements, sign, seal, deliver. As ridiculous as the assertion was, that this man committed a murder with no money up front and $5,000 later on of the $150 that he was promised, okay, it still looks very bad for us. It still looks outrageous, or as the court used, incredible. And this is the court's order where the court utilized the information that the state gave her to make its actual just decision. Not only did the defendant conspire to find a hitman, that's questionable because, of course, we now know the text messages were that of a joke, and I don't know if the court recalls to Detective Johns falsely testifying about a tattoo artist that when Shanna Gardner had asked him about knowing someone, that he stated he didn't think it had anything to do with murder, but yet Detective Johns, in his inability to be honest, said that it was for, in fact, to actually find someone for murder. But she also funded the cost. The $5,000 sent to Tennant as the first payment for killing her ex-husband came from her trust account. Following the money, Fernandez transferred the money from the trust account to the LLC that they co-owned. Ultimately, Fernandez wrote a check from the LLC to pay Tennant for the murder. Defendant argues Fernandez had complete control of their finances and she was unaware of his dealings with Tennant. The defense argument is incredible considering the evidence. Now, I want to go back to the very first slide so we can follow the money once again. Can we go back to the first slide? These prosecutors took these bank statements, and as we all know, they're monthly bank statements. They put them on a PowerPoint, but I would direct the court's attention to look at the statement period for this date, for this specific transaction, which, as you can see, is March 1st of 2021. The murder did not occur until a year later. To put this before the court, to insinuate, and if you look at the very next slide, then we go to April 26. April 1st, 2021 to April 30th, 2021. That is the statement period for these messages. And then if we go to the next slides down, when we get to Henry Tennant's checking account, we're talking about a checking account on March of 2022, not 2021. They want you to follow the money, Your Honor. But they want you to follow their path to the money, which clearly is false and absolutely misleading and has no place before this court. You take this and each and every one of Detective John's lies and all these issues, one after another, after another, after another. It's shocking that we have so much to criticize and so much to point out. But if you even just take this issue here, everybody knows you get your monthly statements. They had to look at March of 2022 and April of 2022 because that's when the murder occurred. And that's when Henry Tennant's telling them he got this money. And it's true, he did get money, but it didn't come from the Shanna Gardner Trust. So what I find even shocking, more shocking, is you got to go back. Okay, well, we don't have any money coming from Shanna Gardner. That's how they tie Shanna Gardner to all of this, through the money. And if you look at back to the April 1 of 2021, just to be clear that it didn't come from the Shanna Gardner Trust, if you look right below their red box that they want you to focus on only, check 1052, he empties out the entire account. It's at 18,000. He writes a check for 16,000. There's no longer any money. There's just 1,900 basically left. So you know now that they're lying to you, misleading you, putting forward false, I guess it's a real document, so I can't call it a false document, but this is shameful and nothing less. And again, it's the only thing, it's what specifically ties Shanna Gardner to these checks and to this money. And just like the truck, where they try to mislead you on that, and just like with the Susan Lee text messages, where they try to mislead you on that, and well, they don't only mislead you, they misled us. We had no ability to defend her on a lot of these issues. And the court knows, look, I think I could have caught it during the hearing, but I'm focused on my cross, I'm focused on what's going on. There's a million things. As a trial lawyer, the court knows there's millions of things, and to go through a detailed bank statement and to be able to pull that out is quite difficult. And then there's this fact. Your Honor, I looked for the actual April and March bank records for this account in the discovery, upon discovering this, and we do not have them. I have asked our co-defendants, Ms. Day, our co-defendants counsel, if they have them, and I'm sure as officers of the court, they can stand up and say they don't have them either.
For 2022?
Correct. So now you have to ask yourself, why are those not? Why are the months of the murder or the months following, the 2 months following the murder, for which they based this whole indictment on, and it's all over the discovery of how these checks were written and how the money came from Mario Fernandez and Shanna Gardner, and all of these facts. But yet, the bank statements disappeared, or we don't have them. That's all I can say. And we come before you to try and get Miss Gardner, have at least her ability to be with her children. And this gets presented before the court. This gets sent to the point where it was detailed in quite significant fashion in your order, for which you considered to deny Miss Gardner's motion. I think, you know, I'm a little stuck where there's just so much here of false and misleading information presented that we had no choice to bring it to your attention. Because I think if you had known the truth, the results may have been different. Your consideration would certainly have been different. And that this court deserves the truth. We all do. And this process is supposed to be a search for the truth, but it is anything but. And one incident, I get it, and I know, and I read the court's order on the motion for disqualification. I know the court was not a fan of what occurred, but we're all human. We all make mistakes. I get it. But this is not a mistake. This is not negligence. This is not bad lawyering. This is a pattern, a clear and distinct pattern of trying to skirt justice and the truth. And it is deeply embedded in the black letter law of this state that this is a death penalty case, and we all know that death is different. I think given all of these things put together, you have reckless conduct by significant members of, by significant witnesses, and I have no idea how something like this would occur, and I can be frank with the court and tell you, upon finding out this information, one of the things that we considered would be knowing that maybe this won't make a difference, and maybe it's best to sit on this card and utilize this during the trial. But it's not, upon discussion and consideration, it's not our job to subvert the truth. It's our job to work towards it. And I don't think we could have sat by and allowed you to think one thing and to be misled under these circumstances and not say anything. A lot of these issues we could have put off, but it's the false statements, the withholding of critical information from the defense, information that's favorable to Ms. Gardner. It's like a cancer that is riddled throughout the evidence in this case, where I don't know if the court can accurately or effectively trust any of it. And I hope the court knows I'm a little bit more articulate than this, but I'm using my words very carefully here. And because I find no pleasure in this whatsoever. I want this process to be a just and fair process. We both want to put on our cases. But I've taken an oath, and I cannot stand by and allow this to happen without calling it out. And it's just a very difficult thing for me to do, but one that I think.
So obviously, this doesn't get brought before the court very often. In fact, it's been urged that I not even hear it. Pre-trial Richardson hearings are rare. They can occur. What are you asking me to do?
Well, I think the court has various remedies, and we outline them in our motion.
What is the authority for a dismissal, though? So let's say I take the position you want me to. I don't know of any authority that gives me that ability to sanction that way. When things are happening pre-trial, the law that I've read is it's exclusion most of the time also is cautioned by the court, and that's a remedy asked for in the motion. So in light of what you've explained to me today, if I were to see it your way, what do you want me to do?
I think, and we're going to pull the exact issue or pull the exact source on this, but I believe that either the rules of procedure or case law give the court the authority and the ability to fashion multiple types of remedies in a case up to and including dismissal. It's a rare remedy. It's rarely granted. I recognize that. But we're really talking about some rare conduct here. And I think for us, obviously, there's a hierarchy of remedies that we would seek. And we certainly do not want to take that off the table in terms of what the court should do. You know, I stand in the shoes of a criminal defense lawyer proudly. And my first reaction would be, yes, this case should be thrown out. It should be tossed because at this point, it has been so infected, even from before when the case started. When you've got lawyers coming in here, smart lawyers, who had the forethought to think, hey, there's some devices with attorney-client privilege that you shouldn't be viewing, and they actually were granted they went through this whole extreme thing, and I'm not going to, restate all of what occurred previously, but all of those things occurred to make sure fair play and justice occurs, and that occurred. Okay, we had the ruling on that, but the conduct continues, and you've got a detective serving subpoenas in Utah where they have no authority to do that. It's essentially a crime. It's a misdemeanor to present something as an official subpoena when in fact it is not. So how do we have a trial with the lead detective continuing through this course of conduct, and all of these things occur, secret meetings occurring without being recording with arguably the most important witness of the case, describing the only piece of evidence in the case that implicates Ms. Gardner? Again, I understand I understood the court's conclusion after being misled with all of these different things, but she's nowhere near the scene of the murder. She is married to an individual, yes, but there are no we didn't go through text messages of Shanna Gardner telling Mario how much she wants him killed or anything, even way back when they first met. Since if these text messages are not stale, there should be things in there that specifically are related to Mario Fernandez and Shanna Gardner, but there's no such thing. You didn't hear about any of that or any of these other individuals. So it's a mess. For lack of a better phrase, it's an absolute mess. Now, in that hierarchy, yes, we would ask for exclusion of these text messages. We've got to do something to stop this type of conduct. Okay, and I'm just a blanket, I'm not calling anybody's names out, but governmental conduct. The only way you can prevent that from happening again is through sanctions to prevent them, and the courts have determined exclusion to be one of those, to be an actual remedy for that cause. And the cause is our government should not be doing this to any citizen accused. Our government should not have detectives on the stand lying to a judge and going off in other states and serving subpoenas that aren't valid and committing misdemeanor crimes over there. And then just one piece of evidence after another that is just a flagrant attempt to mislead the court.
So if I take what's at the back of Ms. the motion that was filed on behalf of Ms. Gardner, it asks for the special jury instruction to draw an inference related to Detective Johns. And I'm familiar with that based on, generally, that comes when there's a specific destruction of evidence. It's a negative inference instruction, so the defense is requesting that potentially, but that's later on down the line. If you were to ask for that. Exclusion of text messages, exclusion of any statements made by Ms. Gardner.
I think the court has to.
And I'm assuming D means reconsider the information at the bond hearing.
Yes, because this misconduct was done in the effort to keep her incarcerated. I think it's only fair that she be released because of it. Otherwise, it has to be a remedy strong enough to prevent them and to discourage them from doing it again. That
Then
didn't
again,
occur.
you ask for disqualification.
Correct. When we did the disqualification, it's interesting because when that argument was going on, I had the ability to observe most of it, if not all, and I don't think they were worried one bit that they was going to be that they were going to be disqualified. Mr. Mizrahi came up there. He didn't have any notes, any case law, it was quite clear that they didn't feel that this was much of enough to warrant anything, and that nothing was going to happen to them. This is much more serious. I can't conceive. I'm having a hard time arguing, because how could they sit here and present this evidence to you and attempt to mislead you and take you down this path where it's shocking, to say the least. And it has to be a shocking response from the court to prevent them from doing it again. If Susan Lee would not have been watching, we would not have been able to bring this to your attention. If Kim Jensen was not watching, we wouldn't have found out until much later on, and who knows how her memory would have been affected as to what occurred on that specific situation. But they all, and even you got a woman in Utah who's watching too, And everybody's outraged by Detective Johns' testimony and mischaracterization of the facts, his reckless disregard for the truth, to the point that they're coming forward. But for these cameras, a citizen accused would be helpless to respond. And we would not have the ability to respond, at least effectively. Well, it certainly wasn't effective enough because our motion got denied. So I think, I think I think it's quite obvious this is a serious matter, serious issues, serious conduct, and again, death is different. We have those marching orders with death penalty cases that while we follow the same rules, the consequences are so much greater, so we have to be that much more in line. We have to follow the law that much more, that much closer. And extra attention needs to be paid, and extra diligence needs to be done, especially from ministers of justice. I think, if I'm not mistaken, the U.S. Supreme Court in Reed was quite clear about our roles in this system. My role is that of her advocate, to be her voice. Their role is to seek the truth, to be ministers of justice, and to not put forward this type of evidence, to not support this type of conduct, and to not be a part of it in any way, shape, or form. That's why they're granted this incredible, awesome power of discretion. They don't give that to just anyone. So if they have the discretion to not only charge someone with murder, but to actually ask for the ultimate penalty of death, there comes with some that comes with a lot of responsibility. And I think that responsibility has fallen, they have fallen very short in terms of their responsibility in that matter. And we think, as we laid out in our motion, we think that this obviously was a situation to prevent Ms. Gardner from being set free during pretrial. At the very minimum, she should be released, at the very minimum. But I think that this conduct goes far beyond that, and I hope the court considers that. That's your Honor's place in our system to make that decision. You call the balls and strikes, and you also make the tough calls. But I don't want to be a part of any of this. And I hope, and I ask that the court not either. I know the court doesn't want to either, but something has to be done about this. And again, I apologize for my lack of fluidity here in terms of my arguments, but I don't make them lightly, and I don't want to say specific names or things like that. And I really have tried my best to do it to the point of the bare minimum while still fulfilling my oath to this woman. Unless the court has any other questions, I rest on those arguments.
I want to be clear, while you're asking the court to do something, I can't do it of my own volition. It has to be a request by the defense. So I want to make sure that what's in your motion is what you're asking me to evaluate as far as potential. If I saw everything your way, that is the potential remedies that you would seek, and I would then decide what the appropriateness of that is based on the information that you've given me in this hearing.
Yes, I would answer in the affirmative that yes, we would seek dismissal. In the alternative, we would seek exclusion. In the alternative, we would seek exclusion and her release. And at the very bare minimum, her release, a reconsideration and her release. I have hesitated saying this before, and I know the court has seen that hesitation before. but I haven't been shy about it either. And I think that I don't want to be dealing with the Hail Mary of a jailhouse snitch, because this type of conduct occurs. She gets stuck in jail, and now we have to deal with someone making things up and just turning this even into a bigger circus than it already is. I don't want to go there, and I have had deep concerns. And look, I also have enough experience to know what happens next, especially when stuff like this is happening. So we really haven't even started this case, and look at all of the mud that we're trying to get through. And it's an incredible mess, and I can't believe this evidence was presented to you. I can't believe that that Detective Johns testified as such. He should be ashamed of himself. And I really think that a strong response from the court is warranted in terms of the relief that the court, we hope, justly decides and executes in this matter.
Thank you.
Your Honor, my response will be brief. I may have to share my time with Ms. Stifler about some particular issues, since many of the things that we heard here today were brought up to our attention for the first time. My only direct response to Mr. Baez is that I have been doing this job that is very dear to me for over 25 years, and I find it very difficult to be lectured about how to be a prosecutor and how to take the solemn responsibility that the people of the state of Florida have entrusted to me, and then to be lectured by a person that stands on the steps of the courthouse and gives press conference in violation of our professional rules of conduct, and then comes into this court and brings up issues that he's never raised before in paper motions, which is the way things are done, which is the way we're taught in law school. If you file a motion and you ask for a remedy, and then Mr. Baez makes up remedies as he's staying here in court about dismissals which were never asked for in the paper pleading, neither was anything having to do with Ms. Lucetti mentioned in the paper pleading, neither was anything mentioned about the defense's different interpretation of the bank records mentioned in any pleading, and that is the only other thing I would say about the banking records is obviously the state is obligated to disclose all evidence in the case. We have gone through great pains to discover the voluminous records in the case. We obviously discovered the records in the case during the course of the hearing. The fact that this is the first time that either Ms. Stifler or I have heard a word about not having these bank records, and then they put it up on a screen in court in front of cameras and say, we never got this. A phone call and email would have sufficed, and we have provided those copies of the records, which we obviously believed were provided in the entire time, if they were not previously provided. With regard to the actual motion and what they're claiming, because obviously all they wanted to do here was to rail on the state and basically have another bond hearing, I want to put in what was previously introduced into evidence, which are the text messages that obviously Ms. Lee and Ms. Jensen have a subjective feeling about what they were about. But of course, what was buried in there is the actual text messages. So just for the record, and you can easily refer to it, Kim Jensen said, quote, Shanna needs a guy, end quote. Susan Lee says, quote, what kind of guy, end quote. Ms. Jensen says, quote, the kind that perform permanent disappearing acts on certain people. Know any magician? End quote. Susan Lee says, quote, I'm a magician. Know that I do not for stupid, end quote. Ms. Jensen says, I was thinking of Thomas, LOL. Ms. Lee says, he isn't a magician, but I'll ask if he knows any. Ms. Lee says, I'm sure he knows a few. So their characterization and subjective belief, which by the way was 100% disclosed before the bond hearing, and if any claim is just false that it wasn't disclosed because they had the grand jury testimony. We have the emails that we have attached to our response that indicate that they knew about all of this. So they argued it, to your honor. So but the objective evidence is what it is. If a defendant comes into court and says, I shot somebody, he can come back later and say he's kidding, but the state doesn't have to disclose that, even though we did disclose it. It's also interesting about the whole concept of Susan Lee, that somehow we're trying to hide the ball when we provided the name Susan Lee to the defense in these text messages. These are all people that are friends of the defendant. The fact that we haven't spoken to her is not evidence of hiding the ball. They found out about her because we disclosed her name. It's part of the evidence in our case. They say that the detective lied and it's some pattern of conduct. They're referring to his partner's reports to impeach him. I know Your Honor is so familiar. So we're talking about the text messages and the reports are things that were disclosed that they have and they're using it to impeach. Mr. Bias spent the last 30 minutes of the argument talking about a record that states what it states. That the funds from Ms. Gardner's account funded Mr. Fernandez's account. There was no hiding of anything. We didn't white out the dates of the transactions or anything like that. The concept that the state of Florida is not allowed to meet with a witness, and I'm glad Mr. Baez actually clarified it because now the court can see the whole purpose behind that. Ms. Jensen, on multiple occasions, sat down with the police and says she knows nothing about this case. No one has no suspects, no idea, no concept of what's happening. Then she's subpoenaed before the grand jury and under oath discloses for the first time that Shanna Gardner told her that the defendant, Mario, her husband, was going to, whatever the catchphrase is, I don't want to say it wrong, the catchphrase about the victim in this case, and that she told him not to. That was, of course, the first time any of that was discovered. And then lo and behold, when we get the search warrant of Ms. Jensen's phone, we discover all these other text messages that show that the conduct went way beyond all of that. Hence, a subsequent bring down to the state attorney's office to discuss it with her and the possibility that she is withholding evidence, which she was, because in that subsequent meeting, as she indicated under oath here today, there were multiple other statements that Ms. Gardner indicated to her about Mr. Mario Fernandez boasting about his ability to take care of whoever it was. I believe it was. So, I mean, they listed Ms. Jensen as a witness, and according to the Florida Rules of Criminal Procedure, they listed her as a witness that they intended to call. That's the defendant's responsibility. They don't have to list anyone that has no. They listed Ms. Jensen as a witness since December 2nd of 2023. We just heard an hour of railing on us withholding evidence, and they had listed the witness since 2023, stating their intent to call that witness. That's the only incredible thing that we've heard here today. Obviously, people can have, in every other respect, I'll rely upon our response. People can have different interpretations. They can come into court and say this was all a joke. That's great. We are in the very beginning pre-trial stages of this case. We're doing our best to make sure that we speedily do discovery. This is not helping. We would like to get our depositions done and get Ms. Gardner in front of a jury of her peers so these wonderful arguments and these wonderful attorneys can make their arguments and stand up and argue with a jury about whether or not Ms. Gardner is guilty or not. And absent any other questions, if Ms. Stiffer wants to add anything with regard to the discovery, I think if the court pleases on that issue.
Your Honor, since I think this was supposed to be a Richardson hearing, so I'm going to address the prongs of Richardson. Whether there was a discovery violation. In their motion, they allege that the state failed to disclose that Ms. Jensen made statements, but that they were quote unquote a joke or made in jest. or that they weren't serious, or that they weren't an actual intention of these women to conspire to murder anybody. Defense counsel, in state's original discovery demand dated, I think, November 13th, 2023, the state disclosed a number of recorded interviews, a number of Ms. Jensen's statements, and Ms. Jensen's, the content of her text messages with Ms. Gardner, which were presented at the Arthur hearing, including a recorded interview with the Jacksonville Beach Police Department from Ms. Jensen, May 6, 2022. In that interview, she did fail to disclose to police that there were any sort of statements by either of the defendants as the ones that were actually discovered once we did a search warrant of her cell phone and once we brought her to grand jury. In a February 3rd, 2023 recorded interview with Jacksonville Beach Police, which was disclosed to defense in our initial demand, Ms. Jensen at some point during that interview tells police that she remembered Shanna Gardner saying 8 years ago, "I wish someone could shut him up," referring to Jared Bridegan, and that Ms. Jensen then spent some time telling the police that everyone who goes through an angry, bitter divorce say things that are not necessarily what you mean. She tells a story about her sister also making comments, as she reiterated here today, the same type of testimony she gave about the lunch bunch, and how people say things about their husbands all the time. So the defense has been in receipt of both of her prior recorded interviews in which she discusses the animosity between Shanna Gardner and Jared Bridegan, and which Ms. Jensen, at both these interviews that are recorded, that have been in possession of defense counsel, does say the exact thing she said today, which is, everybody who goes through a bitter divorce says things. They're not serious, they are made in jest, they were made out of anger, we were venting, et cetera, et cetera. So, defense has had this information that that is her view or how she is skewing these communications with her best friend. I'm sure once she saw the Arthur hearing and heard the word co-conspirator be using with her name, that's probably the basis for the outrage defense counsel is speaking about. In our exhibit to our response, I attached an email between Mr. Carodi and myself, which CC'd all of defense counsel for Ms. Gardner, in which Mr. Carodi says, following up on our conversation yesterday, meaning with myself, I'm going to seek to unseal Ms. Jensen's grand jury testimony and their actual motion to unseal, which references that they were clued in to do so, so to speak, I'm paraphrasing, by the state. So Mr. Baez's motion, he had said that through due diligence of defense counsel alone, they discovered this grand jury transcript, which had all these statements that the state had not otherwise disclosed. But the fact is that Mr. Carodi called me after receiving the state's discovery exhibit specifically to have a conversation about Ms. Jensen's statements, during which I advised him he should seek to unseal the grand jury transcript. And I specifically told him I did not believe it to be Brady because it was not exonerating. It has been known to all sides because Ms. Jensen and Ms. Gardner were very close. And as Detective Johns testified during the bond hearing, when Ms. Jensen received her subpoena for the grand jury, the first phone call she made was to Hank Cox, Ms. Gardner's attorney at the time. And that while she was at the grand jury speaking to Mr. Mizrahi and I in the side room after her testimony, that she was receiving calls from Ms. Gardner over and over and over and over while we sat with her. So they have known about Ms. Jensen's statements, they've had her listed as a witness, they've had her interviews and her grand jury transcript in which she makes multiple statements that old comments about taking care of Jared Bridegan or getting rid of Jared Bridegan or statements about animosity or what they would like to see happen to them were made out of anger, made out of venting, out of resentment and in jest. Those statements are all included in her grand jury transcript, which defense counsel received in January of 2024 after the state of Florida told Mr. Carodi in a phone call, which is corroborated by his email and their own motion to unseal that transcript. So I know we brought that up in our written motion, but none of this is new. Kim Jensen is closely associated with Ms. Shanna Gardner and with her defense team during the entire pendency of the investigation in this case. I disclosed jail calls of Ms. Gardner herself to her defense counsel, in which she's speaking with members of her family about how she said these things, but she never meant them not really. So this defense theory has been known to the defendant, her best friend, her prior counsel, and counsel the entire time this investigation and case has been ongoing. My argument being there has been no discovery violation. There has been no Brady violation. The fact that a co-conspirator says, "I'm not guilty of conspiracy," is not Brady. It is a self-serving statement that is disputed by the context of these text messages and the rest of the evidence that was presented at the Brady hearing. And it's ultimately, I can say I believe the evidence says one thing, they can say we believe it says another. Ms. Jensen can say I'm not guilty of conspiracy. Ms. Gardner can enter a plea of not guilty. It is to the finder of fact, the court in this case, ultimately the jury, previously the grand jury, as to what weight they give all of those arguments. Defense counsel stated that Detective Johns made several affirmative lies on the record and said that I solicited, basically knowingly solicited false statements and made false arguments to the court. That again is simply not true. The statements about the truck, they impeached Detective Johns with a cursory statement in his partner's written report, but they have had the recorded interview of that witness, Jeremy Ordway, in which the actual conversation between Detective Lamont and Mr. Ordway on the date of Henry Tennant's arrest is recorded. The actual content of it and whether or not what was said or not said has been disclosed to them since the state's initial discovery demand. So if they want to take a statement from a report that's a summation, the accuracy of what actually was said is reflected in that interview. And Detective Johns knew the content of that interview, even though he did not know what his partner wrote in a report. So when he's testifying, when I'm asking him questions about Mr. Ordway's knowledge of the case, the fact that detectives came to speak to him, and he said that, basically he said nobody told him, hey, this truck was used in the murder of Jared Bridegan. That was based on his review of the actual recorded interview with this witness, and what the witness was actually told and what the witness actually said. Miss Lee, the texts with Miss Lee were not argued by the state as evidence that this was a solicitation. It was argued to show the very thing which they're arguing, to rebut this argument that Miss Jensen and Miss Gardner were just joking. Because as they're having a conversation about magicians and making things disappear, Miss Jensen reaches out to a friend to ask her, and Mr. Mizrahi read those texts into the record. The court will determine whether or not you believe those texts to be a long-standing joke, or whether, based on those texts and at the time that they're being sent between Miss Jensen and Miss Lee, Miss Jensen and Miss Gardner are having a conversation about wanting him gone. I'm not even joking, quote unquote. So that is just a part of the totality of the evidence, that there was testimony at the Arthur hearing that Miss Gardner also spoke about M, quote unquote, H, quote unquote, her ex-boyfriends, a tattoo artist, that Detective John spoke with a friend of hers who said that Miss Gardner told this friend that Mario could find, quote unquote, find 4 guys and make it look like an accident. All this is as a totality to show her state of mind and her intent. It is not the state's attempt to take one text messages out of context, call it a solicitation and walk away. We never argued it for that purpose. The purpose was to rebut the argument, which they made because they knew that Miss Jensen was somehow joking about this. It stops being a joke when you're talking about it with your friend and then you start reaching out to other people about it. But the court can make your determination of whether you put weight in my argument that that's what it means, or defense argument that's not what it means. But in no way did I affirmatively mislead this court, or the detective affirmatively mislead this court. And his testimony that there was some issue locating Ms. Lee is not untruthful. She did change her address. He and another partner reached out to her to schedule a meeting, and it was supposed to be a local law enforcement agency in the state of Michigan that did that. And it's not grossly inconsistent with what he said, that they had trouble locating her, and then he was seeking help from a colleague to speak with her. He could not remember if a colleague spoke with her or not. And by spoke with her, we all know that he's referring to an actual interview, not merely speaking with someone, hey, I need you to come downtown. I can't, I don't live there anymore. The same thing with Ms. Lucchetti, that she's saying, oh, we were willing to speak with him. He's misleading the court, and the court heard testimony that Mr. Thomas from Intrepid Group and Ms. Lucchetti refused to speak as in an actual not custodial, but an actual interview about the facts, rather than just saying, no thanks, call my lawyer. And then lastly, that there was some gross misconduct by myself or Detective Johns regarding the financial records. The state of Florida never, ever, ever made the argument that those records were contemporaneous with the checks, as if to say, hey, he transferred it and then he immediately wrote a check from that. exactly what Mr. Mizrahi said. We put fuller records into evidence. That was part of the slideshow. The date, I clearly asked, both myself and Detective Johns clearly said those records were from 2021, because the argument was that Mr. Fernandez, and Detective Johns testified it, Mr. Fernandez did what Detective Johns called odd things with the money and was constantly moving money around between accounts, that there were withdrawals from the irrevocable trust fund into that First Choice LLC home rentals account over time consistently prior to the murder. And the important part was those records are important. They don't correspond with the checks. They correspond with Mr. Fernandez's discussions with Henry Tenen, which began in November and December of 2021, that he was moving the money around, beginning these discussions, and that he promised Henry Tenen, as came out from Detective John's testimony, a sum of money of $150,000, which happened to correspond with the December 2021 Christmas gift from the Gardners to Ms. Gardner and Mr. Fernandez. So I never made any attempt to mislead or state the evidence meant something that it did not mean. The records are what they are. And the state also put into evidence, as further proof of her involvement, the filings for the LLC, the yearly filings for 2001 and 2022 from Ms. Gardner. So those records weren't mentioned. I didn't just put in a snippet of 2021 records, say they were from 2022, and try to mislead this court in any way. We put in a multitude of records. We talked about a multitude of financial gifts, transactions, promises, and filings from multiple years. And I have one moment, Your Honor. All of these records, all of these text messages, all of these transcripts, all of these interviews were provided to defense counsel in discovery ahead of this hearing. So in the Richardson aspect, Your Honor, I would ask that you deny the defense motion. There has been no discovery violation. Any information the defense says they are now aware of that they weren't previously aware of, they have had the ability to know about it. They have known about it. None of it is Brady. Ms. Jensen's self-serving, subjective opinions and beliefs are not Brady material. They don't exculpate Ms. Gardner. Frankly, half of them are not admissible in front of a jury. Her opinion as to the guilt or innocence of Ms. Gardner is not relevant or admissible to this court or to any finder of fact. And they're not material because the state acknowledged at the bond hearing. We made arguments on this being a joke versus not a joke and what the totality of the evidence suggested. The state said this is a circumstantial case and it is built on all of the evidence. Each individual piece of evidence can be explained away, but it's the totality of it when the court looks at, with her motive, with her consciousness of guilt and her behavior after the homicide and after the arrest of Henry Tenen, that this court should look to in determining what weight to give defense arguments that she had no knowledge, that she was joking, that she wasn't serious, and that she wasn't involved. We went through this, we argued it, they had the opportunity to do it, Your Honor considered it, in your written order, you wrote about it, and you denied it. So I'm asking Your Honor to find that there has been no discovery violation, there's nothing material and or prejudicial about any of this, and to deny the defense motion.
All right, thank you. Mr. Bias.
Yeah, Judge, I'm shocked.
Mr. Bias, how long?
Huh?
Because we've been going,
No, really brief. I'll wrap it up quick.
because I'm going to give
I got you.
everybody a break.
Understood. I'll
We've been
be
going a long
quick.
time.
I'm just shocked. Not only do they double down on false statements, they make it worse. And I'm gonna be really quick and brief with my bullet points. Number one, all you have to do is, that's why I pointed out the timeline. First comes the grand jury, then then she turns over the phone, and then they have the text messages. Then they have this secret meeting, or this unrecorded meeting with a co-conspirator. So there's no way that the grand jury absolves them of their discovery violation for what occurs in the meeting after they have the text messages. It's absurd on its face. Then Mr. Mizrahi, the first thing he gets up here and says, well, this all could have been solved with an email or asking us for the bank records. If they don't have them, they could have emailed us. Well, we did. We sent them an email on May 24th of this year.
It was actually October 9, 2023, and we sent the same email in May.
So we're asking them for these bank records, and they're still not providing them. And then he's getting up here and he says, well, why didn't you email us? Okay, maybe he just didn't know about that. But then you got the Susan Lee thing. They disclosed her. Yeah, they disclosed her at the 11th hour. The court heard arguments of that, and we were trying to exclude those text messages, and they were, in their, they were coming at us, basically arguing to the contrary why they should be admitted. She laid out her reasons for why it should be admitted, and then we have this. Then Mr. Mizrahi gets up here and he starts telling you about text messages between Miss Jensen and Susan Lee. And then the final thing is, and I have to admit this now, he starts reading, but he leaves out. He's basically trying to argue that it's not a joke. And he reads out loud right now before the court, I'm sure her ex knows a few, as a statement from Susan Lee, meaning in reference to finding a hitman. And I apologize, I jumped right to it, but Susan Lee, I'm thinking Thomas, LOL. That's from Kim. Then, he isn't a magician, but I'll ask if he knows any. I'm sure he knows a few. This is her saying that her husband knows a few hitmen. Okay, that's absurd on his face. But then, while Mr. Mizrahi is telling you these, reading these text messages into the record, he leaves out the very next one after she says, I'm sure he knows a few. The next text message is LOL. It's a joke. It's absurd. And in their PowerPoint, Judge, during the hearing, they deleted the LOL. It's not there. I'm looking at the slide right now, and it goes straight to, I'm sure he knows a few, and the next text message is, are you home? If that's not misleading you, I don't know what is. On top of one thing after another. That's why I'm shocked. I can't believe they're doubling down and then making matters worse, reading text messages to you in the record and leaving out LOL to convince you of something completely different and say, no, this is, the court can make a decision based on these conversations. This is unbelievable. Then you've got the bank records. Ms. Stifler gets up here and tells you that she mentioned 2021. No, she did not. And I invite the court to read the transcripts of her questioning Detective Johns, because when this all came up, that's the first thing I did. And it's clear that's what the court believed, because it's in your order, follow the money. And the court was under that impression as well. And then when you review the transcripts, you're going to notice, because I noticed this, that they give the dates, but they never give the year. And they're specific about the dates. March 26, I don't know the exact date, I don't have it in front of me, but March, and then he goes into the April thing, the April bank records, and it's clear that they are attempting to mislead you into thinking that this money from the Shanna Gardner Trust went into the bank account and then it went to pay a check for tenant, when you know that's absolutely false. And then finally, to talk about the issue with Ordway and the truck, and that we could have used a recording to say what he actually said versus what's in a police report is I think it's a very weak argument at best, because, forgive me, I have this crazy thought that a detective is going to get on the stand and tell the truth, that I won't have to impeach him, that I won't have to call him out for being a liar. But according to Ms. Stifler, I need to have voice recordings on the ready, just to be able to impeach someone, and to let and for full disclosure purposes, what's in the actual transcripts and what's in the actual recording is, he says, Tennant's truck was used in a murder in Jacksonville Beach. That's specifically what was told in that recording. So I don't understand the argument. I don't understand why they would make such a claim, but certainly they certainly don't have the right to leaving out text messages in their, not only in their slides to the court at the Arthur hearing, but right here, right now, in arguing these issues, especially after seeing the court's concerns over what's being presented. So I would submit, I don't know what we have, defense one already?
Up to 4. Correct.
Are we up to 4? Yep. Copy for this.
Any objection?
We don't know, we're looking at it.
Okay. That'll be marked as defense 4 for the hearing.
I promised I'd be brief. I wasn't. Well, I tried to be. And I'll rest on that rather than give continued argument.
Let me see the lawyers at sidebar. All right, when do y'all want to come back?
How long will the court give us?
I'm at y'all's disposal. I have a couple of conflicts, but I'll listen to you all first. If the Gardner case wants to come back to sort this issue out, I'm open for that, and I can separate the two defendants. And then we can reconvene after the depositions. Is that the only deposition that you all have, which is what was set today of the minors?
Yes.
That's all we have on the calendar. We did accomplish a lot of civilian witnesses. Our last court date.
The state's preference is not to separate the defendants. I would assume that we could come back perhaps the last week in September. I'm unavailable that Friday, but I'm available the other parts of the week.
I'm generally available in the first part of that week.
Perhaps Monday, the 23rd, we could do it before we pick any juries that week. Like 8:30 on Monday, the 23rd?
Yes. All right, September 23rd, 8:30 a.m., 406. Pretrial. Both cases.
Thank you.
Thank you.
Come with me.